May I
Lord,
mention?
Please come on Monday.
Praying for relief. Bhattacharya is appearing in this matter.
may I, Lord?
My lord, item number 48, my to direct
Yes, Lord. I was. Lord, am I audible to your Lordship, Lord?
may it appear tomorrow, my lord?
It is appearing. I've taken on Mr. Chatterjee is appearing.
My lord.
Yes, he has mentioned.
Yes, Lord.
Yes.
Praying for relief.
Grave urgency as the matter is fixed before the lower court, my lord.
Already you did not hand over the
Lord,
slip.
I am praying for release of this matter as Mr. Shonak Bhattacharya is appearing in this matter.
All right, to be mentioned.
May I hand over
Lord, item.
Matter for updatation the next day.
Please come on next Monday.
May I be permitted to mention an assigned matter?
The next day.
Maybe.
An assigned matter which has been partly heard by your lordship. Mr. Sabyasachi Chaudhary was leading me. Madhya Pradesh MSME Council. That award which we are
Please
challenging.
mention on Monday. Yes.
Lord, item number 48, Lord, only one thing. Lord, am I audible to your Lordship?
My lord.
Please come on Monday. Please mention on Monday. There's an indication.
May I be permitted?
Can you not wait till next Monday? Yes.
May I be permitted, my lord? Only one application, my lord. For
Yesterday it has been. I could not go through all the slips. Please come on next Monday. No. Please come on next Monday.
My lord,
Lord,
Upgradation
item number
matter-
48, Lord, the
upgradation matters I have
difficulties.
entertained. Please come on next Monday because before next Monday I cannot go through those slips.
may I be permitted, my lord? Only one application, content application, my lord. Inclusion in the list, my lord.
Please come on next Monday. Yes, call the list.
Lord, item number 48, Lord, the only difficulty is,
What
Lord,
is
this
the-
Saturday the matter has been fixed.
it's fixed
Yes,
on
Lord, item number
Sir, I have
48.
told, tomorrow you have said.
grateful, my lord.
Yes,
Great.
Lord, tomorrow, Lord,
Yes.
if you're.
Leave to file the certified copy with the
Why? What is the urgency?
My lord, urgency is that, my lord, I have filed the complaint before the RERA. RERA had issued directions on the developer to give their affidavits. Timeline has 8 weeks has passed, my lord. They have not given the affidavits. I had thereafter gone before the authority to get my matter listed to make.
When have you applied for the certified copy?
My lord, I do not have this slip at the moment, my lord.
Please ascertain then mention.
Lord, I have, my lord, applied.
Please ascertain. Please bring the slip, annex the slip, then mention.
Your lordship, may I be allowed to mention on matter for upgradation, your lordship?
Sir, you have not heard. Please come on next Monday. There's an indication in the list.
Extreme urgency,
Yes,
your
call the list.
But we have not given those judgments.
Why it is for to be mentioned?
Lord, that-
Filing of written notes.
But I have not, Lord, stitched those judgments. Those are already given to your lordships, only the notes.
Only, my lord, I have not relied upon any judgment. Only I distinguished his judgment, whatever Mr. Chakraborty has relied upon. My learned lord
Why
friend,
it is so thick?
Yes,
that's why, my lord, I must be, my lord, kindly, what my learned senior friend has done, whatever judgment the NCRDC, my lord, has relied upon, that judgment my learned friend has annexed. Only, my lord, two assistants, nothing else. Those judgment which has been relied upon by the National Commission.
দেখাসনি এখানে।
আমি দেখাই এই জন্য বলেই দিলাম জজ সাহেবকে আমি কোনো
If you want to rely upon, then
We don't.
no, my lord, if your lordship so desire, but I can not give those judgment, my lord. Only my learned senior friend to assist
if
your
you are
lordship.
relying on those judgments, Mr.
That has
Mukherjee,
been relied upon by the my lord, National
yes, I
Commission.
appreciate. If you are now also relying upon,
No, my
then
lord, I
it's
am not really relying upon any my lord, proposition. It's section 5 only, but I argued on facts and I have distinguished his judgment.
all right.
So your lordship need not even my lord, look into this.
But that alternative argument that I made with regard to that appeal review before the NCDRC, my lord, that alternative argument that I made with regard to appeal review original jurisdiction of NCDRC, but I have, since I have argued, I have given that judgment, but my principal argument remains that
You have given the judgment. You have relied upon that judgment.
Yes, I did.
since I have,
Relied upon, or it's a new judgment, Mr. Chakraborty.
how can I give a new judgment, my lord? My lord may have that trust on me. This is never coming.
That is what no, you have said.
So that judgment, what I have relied on, I have referred that in the notes. But my principal argument remains that it is time barred and limitation. That's
Yes,
the main.
yes, that's.
The written notes of argument. Next.
Or not, they should not proceed with the execution in the meantime. They should not proceed with the execution in the meantime.
It is going on for, it was going
What
on
is the
for
next
last
date?
3 years.
12th is the last day, next date.
12.
12.
You have paid for stay.
Yes, here.
Last occasion, your lordship recorded my undertaking that I will not proceed. That not can be extended. I will instruct my learned advocate.
আচ্ছা তার আগে লিখুন yes
Release Mr. Bhattacharya is acting for the
I'm
opposite.
appearing, Mr. Bhattacharya is appearing on behalf of the opposite party.
We also consent.
the learned advocate appearing for
Same.
next is same order. Next.
I am for the petitioner. Man.
Yes.
This matter came up for hearing before Lordship.
What is the correction?
That's to me, but after hearing your Lordship, written statement of that day.
Oh, 6 weeks. Instead of 6 weeks, it has gone down as 6. It has been.
Everyone does it. This matter was filed under Order 26, Rule 9. So that application was rejected because the Your Lordship wanted to know whether this plot is adjacent to the plot. But I have brought the.
All right. When this matter will come up, I will take up. Yes. Next. Yes.
Well, this, as I had mentioned yesterday, well, this has come up for that.
Yes.
Well, this matter was listed in motion in your lordship's monthly list. In fact, my lord, will kindly see the order I have seen, my lord. Your lordship is probably looking at it. Only because of this order, it has gone down in motion. And my lord, I have been paying through my nose for the last 6 months or so, half of my income altogether, without ascertaining the wife's income, without ascertaining the wife's need, more than what the wife has prayed for. When the wife in the affidavit says that there is no expense.
Any caveat is there?
No caveat, my lord.
Yes. What is the order impugned?
The order impugned, my lord, is to pay a maintenance of 40,000 per month cumulative, 20 in favor of my wife and 20 in favor of my child. I was already paying maintenance under DVX order, 7 and 7,000, total 14,000. In this section 24 Hindu Marriage Act application, it has been interim maintenance has been ascertained at 20,000 and 20,000. There is no reason or basis for that. Apart from my income only, my expenses and other liabilities has not been taken into account. The expenses awarded is more than the prayers. Why, when in the affidavit, the wife says that there is no expenses in maintaining herself or the child. Complete non-application of mine.
The wife is having an independent income.
No. He stays with the in-laws, my in-laws. I am on the quantum. In the fourth paragraph of the impugned order, my lord, at the last sentence of the fourth paragraph, petitioner has placed her estimated monthly expenses as has paid for maintenance accordingly. In the affidavit, the monthly expenses is being stated as nil. Complete non-application of mind, and thereafter, my lord, no reasoning. At page 3 of the impugned order, the first sentence, this court is of the considered view that an award of alimony pending, there is no basis, no finding, nothing. Apart from my admission of my monthly income being 85,000 odd. I was already paying maintenance in terms of other court's orders at the DV Act, 7,000 and 7,000.
Where is the application? Section 24.
My lord, the section 24 applications, if your lordship sees at page 47, the prayers are at, take your lordship to the prayers also at page 52. My lord, the prayer for maintenance of child, though I am not shying away from paying my child also, is 15,000. The award was of 20,000, more than what was paid for, without taking into account anything.
No, the prayer is 55,000.
20,000, yes, 55,000 is cumulative, 35,000 towards the petitioner, 15,000 towards education expenses.
Yes,
But
total she has paid for 55,000.
Yes, and within that 15 was for the child. What was awarded was 20 for the child. I don't shy away from paying my child. But as far as my wife is concerned, and my lord will also kindly take a note of the assertions in the affidavit at page 84, my wife's affidavit. She says at entry 7 under A, personal information, general monthly expenses of the applicant, rent, household expense, medical
Page
84, which is the second page of the affidavit filed by my wife. Entry 7 of the first table, general expenses inclusive of everything is nil. This is what she files in affidavit. And my lord will also see at page 3, entry 5 of the first table, the approximate expense incurred on the account of dependent, no. Then she goes on later to give some account of the expenses for the child, which again I most humbly say that I don't shy away from paying.
No, but in page 86 she has given the details. 86.
Yes, for the child only.
Yes.
Not for herself, while also asserting that her expenses is nil. And it is not a fact that she was completely without maintenance, because I was paying maintenance to her under orders of others court. It was abruptly, and my lord, I understand that this would have had fallen from the learned trial court on appreciation of the evidence or the prima facie facts of the case. Nothing, if your lordship will kindly look at the impugned order, nothing has gone down in the order. Absolutely nothing has gone down in the order. Completely unreasonable. My lord, I already take care of my child's welfare in the form of, my lord, medical insurances, etc. I pay a rent of 15,000, EMI of flat of 29,000. My son's medical insurance is of 11,000. I have to look after my aged parents whose medical expenses at least I incur 10,000 per month, my lord. I incur an expense of 60 to 60.
So you are paying 14,000 under the DV Act.
Yes, for the child and the mother.
For where is that order? Have you annexed that?
Yes.
Where is that?
It's also at the affidavit also, my lord, will kindly see.
Please show me the order. Have you annexed the order?
Yes.
Where is
My
that?
lord, at page 20, your lordship will kindly see.
20.
2020. My lord, the operative portion is at page 4. Paragraph 18 at page 4, internal page 4, which is page 23 of the application. 7,000 and 7,000 to the 14,000.
But that amount has also not been adjusted.
No.
Ashun. Instructions, if that is so, I think it can be expedited. Otherwise,
Next time, Lord, I will come back because my Lord will kindly forgive me. This was a long standing Lord, and only yesterday your Lordship has allowed this to be placed.
yes, next.
That matter, Lord, you may kindly remember that the custody.
Lord, in this matter, I am late by Mr. Parthopratim Rai, my lord. He has not come to court today due to some personal reasons.
There is no chance of compromise.
But-
District judge has no.
Compromise failed.
Yes.
No, my lord. My mediation has not been referred, my lord.
No, it is.
Where is Mr. Rai?
My client is
He
here.
is in some personal difficulty, my lord.
Mr. Ghosh, Mr. Rai is in personal difficulty
He is in
today.
personal difficulty.
So when he will be available?
But kindly give us 1 week's time, my lord. 1 week's time. Kindly,
Lord,
kindly, my lord.
My client is without the girl, 5 years old girl.
We have
taken
given
from
visitation.
Bangalore.
We have given visitation.
Made application.
He will not be coming for the entire week.
Milord, we have given
I'm asking you, Mr. Rai will not be available for the entire week or for today and tomorrow.
subject correction today and tomorrow. I'm just
So I'm keeping it day after tomorrow. On the prayer of the learned. Friday. All right. On the joint prayer of the learned. আমার নেক্সট ফিক্স বললে ডেটটা লিখে দেবেন।
I have been engaged by the legal aid service. Yesterday, my lord, client himself has mentioned the matter, my lord. There are two matters, my lord.
You are for the petitioner.
I am for the, so far the item number 8 is concerned. In one, I am for the petitioner, other I am for the respondent. Other last occasion, your lordship was pleased to hear
Yes,
the matter.
no, this matter was, Mr. Ghosh, I'm telling you, this matter was mentioned because in the list, there was an indication that it is for release because it is being carried forward from the earlier bench because this matter has been assigned before this bench.
That is all
So
right.
then, because that since that
Your
nothing
lordship,
was there and it
yes.
was mentioned because that is why I directed. Thereafter, it was
My
pointed
lord,
out that it has
directed
been
the matter
assigned
to be
before
assigned
this.
by the Honorable Chief Justice in view of your lordship's absence of determination regarding the year.
Yes.
But that's why after if assigned to your lordship, Lord, we have no objection. Lord, your lordship kindly fix the date because I have been engaged
What is
by
this
the
matter?
Lord, matter is Lord the item number 7 is concerned. Lord, there is we are praying for 7 is concerned, my lord. We are praying for police protection, but that has been denied by the Lanet court below. We have filed a revisional.
No, that matter, I think once I heard thereafter
Yes.
two matters were.
Lord, order 21 rule 32, they have not filed. It is a degree of permanent injunction. We have preferred appeal. And stay application was rejected on the ground that you make an application for injunction. Injunction application, they
All right, when shall I keep it?
Lord, next week.
Next
Lord,
week, next 11th,
Any
my
day.
lord, 11th.
11th.
And my lord, my client has prepared so far the supplementary.
11 তারিখ বেশি আছে কবে কম আছে বলুন তো? Petition
Because lower court has fixed the matter on 14.
কালকে দিলাম কোন দিন কম আছে? 12 তারিখ কম আছে? হ্যাঁ 12th.
And then 2 p.m.
Why 2 p.m. That's difficult.
No.
In the
And my lord, I am for the petitioner. But, this is the affidavit of service, my lord, pursuant to the last order, my lord. 9 and 10, my lord, similar, my lord. This is the affidavit of service in respect of 10.
you are appearing
Yes, Lordship.
for the opposite party.
Yes. Lordship, I am opposing this one. Kindly fix it for. I'm led by Mr.
Lord,
Vaidwan.
The only contention is that the 7-1 application is hopelessly barred by limitation. Let them satisfy that this is within time, then I will accept the order. When they receive the summons and when the application has been filed. Only this point is to be satisfied. Let them show that when they receive the summon and when the 7-1 application is filed. If it is within time, I will not press my divisional application. That is the
Yes.
sole ground.
I am led by Mr. Anirban Kaur. Kindly fix this matter.
You are led by Mr.
Anirban Kaur.
Where is he?
He's on legs in another court, my lord.
I'm passing it over. Pass
Great,
over.
My lord, take up the matter tomorrow, my lord.
Why pass over? If he comes, it can be done today itself.
Great.
Pass over.
9 and
Next.
10, my lord.
9 and 10, pass over next.
10, 10, same.
Both same thing.
Same.
Yes,
In
next.
respect of separate tendency. 11, my lord,
I am for the opposite party.
is for the opposite party. I am for the petitioner.
Yes, what is this matter?
My lord, the application, this is for extension. My lord, the order on Rule 10 application filed by the third party has been allowed. In ejectment suit, my lord.
Yes, Mr. Chakraborty, how can a third party be
I'm not prepared for today, my lord.
in a suit for eviction? How a third party can be added as a party?
That I will see.
Tomorrow I'm keeping.
No, my lord, any date.
Why?
Well, any other date, my lord. Next week or
Day after tomorrow?
if your lordship so man hard.
Sir, Chakraborty,
All are there are judgments.
third party in a suit for eviction.
My lord, there are some exceptions.
All right, bring those. You are aware of those.
My lord,
I'm keeping it day after tomorrow.
Subhakumar Mukherjee judgment is there and other judgments.
Third parties in a suit for eviction, bring those line of decisions if you are aware of those.
Yes.
So, one night is sufficient.
Many dates may be fixed, my lord, after some period.
Day after tomorrow, same heading. Interim order is till which date?
Till July, my lord.
Till July.
Yes.
When is the next date fixed?
September.
September in the trial court. So I'm keeping it day after tomorrow. Day after tomorrow. List this matter on the prayer of Mr. Chakraborty, learned advocate for the petition. List this matter. The interim order is till which date?
Till July.
Why have you not mentioned earlier? File an application. It has
My
expired.
lord, July. Your lordship.
Yes, now we are in August.
My lord, just
Why
we
did
are
not
on
why did not text us for extension?
It is only on 4th. My lord, today is 4th. Lordship, kindly consider this. They have appeared only
My
one
lord, on
day.
behalf of the opposite party, my lord, we have not received any notice, my lord, before the mentioning, my lord.
The matter is running in the list, my lord.
But my lord,
Sir, hi, if you have want to extend the interim order, you know they are appearing. Why have you not notified them? Yes, what is this matter? What is this matter?
Yes. Order 26, Rule 9 application filed by the plaintiff in the suit for declaration and injunction that has been allowed by the learned court. I am the defendant there. My lord, I have already pointed out to your lordship that the point for local inspection, this is the second round of litigation, second application. The first application was disposed of, commissioner was appointed, plaint is not amended, they are asking for local inspection.
my lord, may I pray for a short password, my lord? My lord,
The,
kindly, my lord.
Number 13, I am for the opposite party.
The petitioner, my lord, the interim order expired by the end of July. I have filed an application for extension. Can let it be
yes.
extended.
Why did not text us for extending?
Lordship mentioned, but we could not get it listed.
Yes, what is the impugned order?
Lordship, in an
Order
eviction, Lordship, my application under Order 8, Rule 9 was rejected at the stage of
Eviction suit.
Yes.
Order 8 rule, you are the defendant. Additional written statement, why?
What happened, Lordship, during the pendency of the appeal of the suit, Lordship, I came to know that some portion of the suit property the landlord has already sold. So, Lordship, I called the purchasers of those property. I wanted to issue subpoena. The court rejected my application saying that it is not on your pleading. Now, after some day, I file an application to bring it on record. That is also rejected. So, both challenging both the orders, Lordship, I preferred this revisional application.
What do you say?
Just in the morning I got the brief. That is why.
Just in the morning you got the brief.
Yes, that is why. Kindly fix
10/2 of 2026. This
Matter.
yes.
For the opposite party, my lord, I shall file my vakalatnama within the course of the day.
Opposite party.
Yes, ma'am.
Respondent number 1.
Vedikata. Yes, ma'am, opposite.
Respondent number 1.
The application arising out of the order passed by Lanet 4th Civil Justice Senior Division Alipur in an application under Order 26 Rule 1, my lord. Appointing of the Advocate Commissioner for examination of the witness of the plaintiff number 1 in the probate proceeding original suit. They have preferred an application and the trial court has passed their order. But in the application, they preferred a place for witness within the 3 kilometers from the court. And Lanet court passed an order within 1500 kilometers from the court at Gurgaon.
No, I could not follow.
They preferred a place for the conducting of witness within 3 kilometers in Kolkata for the conducting witness, a place. Lanet court passed the order, the place at Gurgaon, 1500 kilometers away from Kolkata. And they stated in their application they will bond all the expenses for the witness proceedings, commission proceedings. And the Lanet court has passed the order. The order contained is in page number.
Where is the application?
My lord, I haven't received the copy of the application yet.
Where is the there is a caveat.
No.
Yes, my
There is
lord.
no
I have
caveat.
filed a caveat. Yes, my lord. My lord, but
When did you file the caveat?
I have filed it on 23rd of July
So
2026.
it's after the filing of the civil division.
I was not aware of the filing.
Caveat you have to file it,
No
lodge it.
doubt that
Yes.
it was already filed.
There is also a procedure in the appellate side rules how to lodge a caveat after a matter is filed. You have not followed that.
I was not even aware that it was already filed, my lord.
For that you have to, when you are filing the caveat, you have to make
Check,
yourself.
my lord.
Yes, where is the application?
Is page number 77, running page number 77. In page number 78, paragraph number 8, 7 and 8. The petitioner states,
Paragraph number
7 and 8. Specifically the 8.
Yes, where is the residence of the attesting witness?
Well, it is attesting witness. The applicant is the witness, the petitioner, plaintiff number 1. And they are praying for the attesting witness.
Applicant Shukla Sengupta.
Is the plaintiff number 1.
My lord, when the application was filed in the year 2025, she used to reside in Kolkata. Then she shifted to Gurgaon. And the order was passed on 18th
But
of
this
June
says that
2026.
it's with regard to the attesting witness, not the
Sure,
applicant, paragraph 8.
And I'm for Shukla Sengupta.
But here in the body of the application, you have said that the it's address of the attesting witness 3 kilometers.
No, she used to reside here only in Kolkata. She used to reside in Kolkata at that point of time.
Then
Not
so you have
maybe
not
this-
made out. You have not made out that case. You have not made out that case. That you have now shifted to a different place. Where is that? In the application, it has not been stated.
My lord, in the application, when it was made, it was not stated, but
Then,
the order was
then
passed after 1 year.
how could the court pass an order on that?
It was submitted before the court that she later shifted, my lord. And the cost and everything is borne by the.
Maybe you have to take out a fresh application.
My lord, may I receive a copy of the application and come up with instructions, my lord?
All right, please. When this matter is taken up for hearing.
My lord, I am for the petitioner, my lord. I am running with high fever, my lord. Kindly take it up, my lord. Not this week, my lord.
Not this?
Not this week, my lord.
What is this matter? What is this matter? Please move.
My lord,
No adjournment. Yes.
My lord, matter is about, my lord, section 8 of.
Please use the microphone.
My lord, my voice is not there because microphone is there, my lord. My voice is not.
Microphone টা ঠিক আছে কিনা একটু দেখে নিন তো।
Yes. Microphone is.
Yes.
My voice is not.
Yes. Now I can hear you. Yes.
Section 8, my lord, dismissal from the Section 8 Land Reforms Act, my lord. Preemption application was allowed. I am for the, my lord, before the
PMT.
My lord. Thereafter, my lord, we preferred an appeal. Appeal is pending, my lord, and not pending means my appeal was dismissed for default. My lord, there is we file an application for restoration that is pending, my lord. In the meantime, my lord, they preferred an execution application, and bailiff is going to the property to take back the property, my lord. This is the situation, my lord, and we preferred. And
what is the application you have filed?
We have filed, my lord, section 47, my lord. In the
on what ground?
Because my your lordship kindly take up.
Your facial expression shows there is nothing in it.
Nothing is, my appeal is pending, my lord.
Maybe fight it out in the appeal.
Well,
what is the ground in the application?
Well, ground in the application, my lord. Huge material irregularity in the, my lord, section 8 application order, my lord.
So according to you, you are a co-sharer.
My
so
lord.
preemption application cannot be filed. That cannot be a ground in this execution.
My lord, make it an observation to proceed with the appeal, my lord.
I leave you free to proceed with the appeal. This application,
make it an observation, please, my lord.
This application under Article Yes.
Petitioner, my lord. My lord, the petitioners are not interested to go with this application, my lord. They want to withdraw.
They want to withdraw.
Miss, my lord, just one prayer on behalf of me, my lord. Just order of an expeditious disposal of the application.
You want?
Expeditious disposal.
Of what?
Of the suit.
Of the suit?
Yes.
So withdrawal, that order cannot be passed. So I can record that you are not pressing your challenge with regard to the impugned order. First of the learned advocate. Yes.
Lordship 17, I appear on behalf of the petitioner.
Yes.
Lordship, the factual backdrop of the matter is, Lordship, the taken a distance from us. Lordship, on 28/11.
What do you want? What do you want? What is
Lordship,
your prayer?
I want expeditious disposal of the instant SURFACE application, your
This
Lordship.
application under Article 227 of the Constitution.
My lord, Mr. Taruknath Haldar is appearing for the opposite party. In the morning, he has intimated me that due to some personal difficulty, he has been unable to come to court. There is some problem in his family. If I'm only praying for not.
We want to withdraw the application, my lord, because an unintentional mistake was occurred. That a wrong order copy was annexed by my junior, my lord.
Wrong order copy?
My lord, at page 56, the earlier order which they have challenged. That is why I want to withdraw this application, my lord, and kindly give me the liberty to file afresh.
No, what is the order under challenge? Order under challenge is 17th of June 2026.
No, my lord, it is the order which is annexed in page 56. It is very much impugned in this particular matter because last occasion, my lord has passed an order.
Yes.
Specifically, the amendment will allow on paragraph number 5 and 6. But in that order, which I have challenged, in that order, particular order, it is mentioned that is no mentioning of paragraph 5 and 6. They have allowed the entire amendment application, which affects seriously the suit. The effect is that, my lord, the suit value will be changed. The jurisdiction will be changed.
All right. After yes. Not now, please. There is a procedure. Please do that.
My lord, I will
after that.
according.
Yes. Who is appearing? Who is appearing for the petitioner? None appears for the petitioner. Liberty to pray for preponement. It's difficult. After going there, you will file an application that will be against fixed, put up petition. So it will go after December. Yes, next.
But in the application under section 8 of the WBLR Act, I was the opposite party. Lord, I lost in both the courts. Then, Lord, the civil revisional application has been filed before this honorable court. In that civil revisional application, order was passed not to create any third-party interest over this scheduled property. Civil revisional application still pending here. Lord, during pendency of the civil revisional application, the order was put into execution. And Lord, the position I was dispossessed from the property. And that order thereafter.
You have been dispossessed.
Yes, Lord. Then, Lord, I filed an application for recalling, showing that there is an order passed by this honorable court. That application was rejected by the order impugned.
What can be done now? You have been dispossessed. Order has been executed. Succeed in the civil division application, then we apply for restoration of possession.
Kindly, Lord, let both the case be heard together.
There is nothing here because
otherwise, Lord, kindly let this both the matter be heard
there
together.
is you have to succeed on that. If you succeed on that, your prayer will be for restoration of possession. So do that. There is a provision in the civil procedure code for that. There's nothing here.
But
once it has been executed, what remains here?
By blood, the suppressing the material fact is the order impugned, blood order number 45. I am showing from the record. Blood, there is a note that there is no order passed by this honorable court.
Order number
45. Kindly see the order number 45 of this blood, the certified copy.
Yes. Please show me the order passed by this honorable court.
Yes.
Where is that order?
But that is. Lord, page 14.
Page
14.
40?
14.
14.
Sorry, Lord.
No.
44. Page 40.
44.
Hello.
Sir, where is the difficulty? Not to create any third-party interest. So no third-party interest has been created. There was no stay of operation of the judgment and degree.
Lord, they kindly come to page order number 45. Blood, page 57.
So this order does not help you. No creation of third-party interest. So it's transfer. There is no transfer here. That's not your allegation.
But the order is.
And you ought to have prayed for a different order. How does it help you? Get the civil division application disposed of, then
let both the matter be heard.
There is nothing here. I give you liberty to proceed with that. Ashun. 22 yes. Yes, Mr. Banerjee.
That we appear on behalf of the opposite party.
My learned friend is taking a preliminary point of maintainability revision from DRT's order.
Revision code DRT.
Revision from DRT's order.
Yes, he is entitled to take the point of.
Yes, ma'am.
So before he takes,
You are accepting that.
Before he takes,
You are not accepting.
no, not at all. Not
Why?
At all. What DRT has done, DRT has not granted a decree for divorce. Not to that extent, but something close to that. DRT has done. Which is why I say, absolute refusal to exercise jurisdiction. I just indicate, my lord did not look at the records also. I have gone through my lord's own order. Where
What order? In this proceeding?
No, not in this. Not in this proceeding. My lord would remember, Prosenjit Sen. My lord would remember that. So, I know my lord.
Prosenjit Sen, I think the Supreme Court order judgment was also considered.
All the decisions.
Order 7, Rule 11.
Including those, yes, that educational society. So, my lord has shown them the door. Who was there, appearing for the petitioner. But I have a case which is covered under the decisions my lord have discussed, where Supreme Court has said, in these cases, revisional application is maintainable. I just indicate what has happened, need not look at the records. First essay, I call it essay, section 17 application, filed from demand notice and possession notice, normal symbolic possession notice. In course of pendency of this proceeding, comes section 14 order. I had two options. To my humble understanding, I was left with one option only. I did not file an interlocutory application because I thought, and which possibly my lord would agree with me, that this is subsequent cause of action, and 14 is an extended arm of 13.4. So many times Supreme Court has said so. Because possession is taken under 13.4, so 14 is an extension of 13.4. So the moment section 14 order came, I filed a second essay.
Is it maintainable, Mr. Banerjee?
This is only what is maintainable.
Maintainable?
This is only what is maintainable.
Only one thing, Mr. Let us take another type
Not
of a case.
Suit. Not a suit.
So I'm going by the suit. Declaration of title and permanent injunction.
Yes. Makes a construction.
No, in the meantime, you have been dispossessed. So you have to file another suit. What does the law say?
Yes. May I post the
It's a subsequent cause of action.
Taking this analogy.
It's a subsequent cause of action.
Firstly, this analogy would not apply. But let me take the analogy which has fallen from your lordship.
All right, you can proceed on your own matter. You need not trouble yourself with the suit. Yes.
Great.
So according to you, this
according to me, according to Honorable Supreme Court, every step taken gives rise to a different cause of action as a level under section.
Then what happened? You have filed a
second essay. While considering the second essay, the tribunals, which is impugned here, the tribunal says go and file an IA because this is hit by, this is interesting, section 10 CPC. While I was asking for interim order.
Whether section 10 will apply?
Underlying provisions of CPC because of
yes,
section 20.
Principles may apply.
Underlying principles.
Principles may apply.
Interim application, I asked for an interim protection from section 14 order. The learned tribunal below invoke section 10, which applies to hearing of suit. This is something.
But, Mr. Banerjee, what is the difficulty in filing an IA? IA was also maintainable. Can you say IA is not maintainable?
I am the plaintiff. I am the dominus litis.
Maybe. Mr. Banerjee, something is to prevent multiplicity of litigation. After all, the challenge is the same. Because the ultimate challenge is your surface application where you have questioned the declaration of NPA and the...
May pause here for kindly allow me. I may lose on the issue of declaration of NPA. I may lose on the issue of maintainability of 13.2. I may lose on the sustainability of 13.4 notice. But the section 14 order, independent of this, can be bad in law.
What is the impugned order? Please show me.
কিচ্ছু লাগবে না, চুপচাপ। 77 kindly come.
277.
Milord, this is
But
somewhere in the
I
middle
have a
of the.
certified copy, last document in this second volume, I think.
Yes, Milord.
It's a longish one. I do not know.
Milord, there are two
where it
copies.
starts.
First one is Milord Savar. the second
20th
one is
July 2026.
20th July 20.
Yes, yes.
Page,
Yes.
my lord. My lord will look into the fifth page.
Joshua, come on.
No, no, no.
Milord,
If both these two proceedings are clubbed, where is the difficulty?
No, my
no
lord,
difficulty.
there is
For me, there is no difficulty.
but my lord, only one, my lord.
Both the two proceedings are clubbed.
And
Where is the
section 14
difficulty?
It will be treated as an application before
It
this,
are.
because my lord,
Maybe application, main proceedings, the prayer is to quash. Let both these two proceedings are hard analogously. Where is the difficulty?
well, my lord, they have already been given this thing, my lord. If your lordship looks into the order impugned,
They are already been given.
my lord, the second proceeding has been stayed till such time the first proceeding comes to an reasonable conclusion.
Yes.
Now, my
So
lord,
if both the two proceedings are hard analogously,
yes,
where is the difficulty?
then
And
my
this
lord, my
IA
lord
should
will
be
have to-
revived. This IA, I mean, look, this IA in the
has to
second essay, that should be revived.
My lord,
He
it has,
refuses to entertain.
my lord, the second
Citing
application.
section 10.
My lord, if
So
I
where
may
is the
only-
difficulty in hearing these two analogously?
No difficulty. Only one factor remains, my lord, because both happens to be, my lord, a proceeding under section 17. Now, your lordship has, my lord, looked into several decisions. We are not going into those things. Now, my lord, it is an offshoot of 13.4. 13.4, and my lord, it's a limb. 14, section 14 is only for taking possession. So it flows from, my lord, 13.4. So, my lord, if there are two section 17 application, my lord, in subsequent proceedings, my lord, it will create some problem. So, my lord, what is the difficulty? If I may put this
two
question to myself.
proceedings cannot be directed to be hard analogously.
No, that can be hard. My lord, one has to be treated as an application of the
No.
first
Why?
section 17.
Two suits can also be hard to be decided analogously.
Yes, but my lord,
So why not two surfacey proceedings? Do you have an authority that two surfacey applications cannot be directed to be hard analogously?
no, my lord,
Then-
my lord, this is what I, my lord, submit before your lord.
Why one should be a subsidiary? Decide both of them. Where is the difficulty? Yes, Mr. Banerjee, please show that this is a subsequent cause of action for that subsequent during the pendency of parent.
And Milord, this is, I mean, there are so many. But I know a question would come, Milord, from your lordship after reading this. Milord, I answer to that also. অশোক সমিল এনেছিস?
Mr. Banerjee, are you suggesting that IA in the earlier essay is not maintainable for this relief?
This
It's not maintainable.
This is a tricky question. I am not saying it is not. I am not.
So if it is maintainable, why should you not be relegated to file an application there? That's the exact liberty which has been granted. Go there, file an interlocutory application.
May I answer this? Milord, may I answer this by putting a question to
So
myself?
then I will hold that IA is not maintainable. If you say that you cannot go there, you have to make submissions. IA is not maintainable, challenging the subsequent acts. And each is a separate section 17.
Yes. May I?
Yes. Because my reading of that is different. Cannot each step you will be challenging by section 17.
Milord, if Milord holds this today, Milord, a portion of the diatute collapse. Milord, I am not bothered about the consequences. And Milord, which has collapsed to revive. I tell you, Lordship, Milord, why? Milord is aware of Milord the division bench decision presided over by Milord Justice Bhaskar Bhattacharya, Akshat Commercial, which says 45 days and that's it. Not on the 46th day I can file an essay. Now, Milord, I file an essay. Milord, given to a particular cause of action, on the basis of a particular cause of action. Milord, since this is an originating proceeding, Milord Justice Bhaskar Bhattacharya was of the view that, Milord,
No, Mr. Banerjee, instead of
Milord,
going to this, is it your submission that IA in the previous is not maintainable? Because otherwise this will be an academic
Milord,
exercise.
I'm just wondering aloud. I'm not making any specific submission on that.
You have to make that. Otherwise, because Mr. Banerjee, this order has not said anything. This order has said applicant
refused to exercise jurisdiction.
No,
Or Milord, an absolutely misinterpretation.
only one thing, but you have been given liberty to approach the learned
Milord, I was
DRT
not
to
there before the learned tribunal asking for a liberty. Milord, I applied before the learned tribunal, ventilating my grievances and claiming my right.
All right, I give you liberty, file an application for review there.
For review?
Yes.
Of Milord this order?
Yes, place this judgment.
Yes. Until such time, Milord, the section 14 order should not be implemented. Milord, I cannot be Milord baked twice, Milord.
Sir Banerjee, I think something
Milord, I
went wrong
readily
because
agree to what has fallen from your
yes,
lordship.
because
I readily agree.
the tribunal said it's a forum shopping.
It's
Because
not, Milord, I readily agree.
Because in many matters I've come across section 14 order has been challenged. Yesterday I've delivered 2 judgments on that. Section 14 orders challenged in IA. So if you are suggesting, then I have to hold that.
I'm not saying so.
Then, so if you are not saying that, what prevents you from going there by filing an application? That liberty has been given. I clarify all those. Say that these observations will not be they will not be in place. I give you liberty to take out an application.
Milord, why?
Otherwise,
I tell you, Lordship, Milord, why? Firstly, Milord, law has given me, Milord, 2 entrances. Milord has left it to my discretion through which entry, Milord, I can enter, Milord, DRT. Milord, DRT cannot, Milord, close one of the 2 doors. When law has given me, Milord, access through 2 doors, I am the dominus litis. It's my choice that, Milord, my access to justice through a particular entry, Milord, door cannot be restricted or impeded. DRT has no business. Milord,
what is the submission on this?
I will, my lord, your lordship, it has fallen from your lordship that 2 matters. Your lordship, you look into the matters.
So he says that these are distinct causes of action. He's citing this. Have you considered this?
Yes, my lord. Your lordship will look into the facts. My lord, I
have
will
you
tell
considered this judgment, or you want to come back after considering this?
My lord, I don't know the citation.
Then I'm keeping it tomorrow. Then I'm keeping it. Mr. Banerjee, I'm keeping it tomorrow.
Paragraph 22.
Paragraph?
Milord, I owe, Milord, a gratitude to my learned junior.
If section 14 comes as an independent proceeding where the person has not preferred and 13 for application, then, my lord, it can be hold.
Seals it. Paragraph 23, my lord, seals the fate.
Yes, and if there is already an section 13.4 my lord, proceeding from section 13.4, then my lord, an application is the my lord remedy.
No, this is on auction sale. Please show me section 14. Judgment on section 14.
14 is nothing but 13.4.
Yes. Mr.
Any
Banerjee,
measure
this
under
is
13.4.
auction sale held. That was challenged. Thereafter, subsequent stages.
If-
Show me that section 14. There is a distinction between this, Mr.
Not at all. You know, this dichotomy.
Please show me. Do you have an authority on
Yes.
section 14? Please show me that, because these two decisions are on auction sale.
That is an extension, my lord. I'm not carrying today. I can place my lord tomorrow.
Because
There are
these
so
two
many-
decisions
so many-
are on
so many.
auction sale. So I've seen this.
Supreme Court says
I have
this
seen,
dichotomy is not there. There is no dichotomy in the statute.
Mr.
14 is nothing but 13.4. Nothing but 13.
Yes, if you say that, once you have challenged 13.4, then can you say yes? So from 14, I will again challenge.
Multifaceted 13.4, my lord. I can challenge every
These
13.4
judgments,
in every
Mr.
single
Banerjee,
essay.
are distinguishable on facts. I'm telling you.
When there is my lord,
These judgments,
happily
I've
come
seen
back.
those two paragraphs for
I'll
which
happily come
I
back.
wanted to give you liberty and other things.
But I'm ready with the liberty. My lord, I am
And
amenable to the proposal.
let me see. I think I should decide this, because this two-pronged should not be allowed.
It's not two-pronged.
Yes.
My lord,
Yes,
tier two collapse. My lord, I tell your lordship. My
Now
lord,
you
that
will
is it.
again file. So it will nothing but it will multiply litigation. Nothing
No,
more
my lord,
than
it
that.
does not.
Yes.
If law, my lord, permits that, DAT has no business to stop me. If law permits.
Yes. So you can come up with the decisions
Lord, kindly give
tomorrow.
me a happy weekend, my lord, I'll come back. Because the way, my lord, the questions.
You are ready with this matter, Mr. Banerjee.
I am. But
So
tomorrow I'm, my lord,
so you are
otherwise,
ready with these matters. You have the judgments with you.
my lord, I have. My lord, my learned juniors are here. My lord, both of them are much more competent than I am. My lord, tomorrow and day after, I'm a little occupied, unfortunately. My lord.
Tomorrow, so I'm keeping it on Friday. List this matter. After some argument, Mr. Banerjee, learned
My lord,
But then I don't think anything will be happening in 2 days. And not to let it remain, but otherwise again, that again goes
I'm
against.
keeping it on Friday.
but I believe that, my lord, nothing would happen.
My lord has heard
If
Mr.
it
Banerjee
happens,
and
my lord, then paragraph 23, my lord,
It is
gets
before your
applicable
lordship,
more.
my lord. It is before your lordship. If anything happens also, my lord, it is before
Please
your lordship.
instruct your officers not
Yes.
to change the, I'm not passing any
No, no.
order. Yes, next.
Grateful, man. Grateful.
23. Yes.
Early disposal is a suit of 20.
Expeditious disposal of suit.
Yes, my lord.
What is the stage of the suit?
And till date, they have not filed, my lord, written objection, and my lord.
Till date, they have not filed?
Yeah, till date, not. And my lord, we find, my lord, they have prepared appeal, and after the appeal, status quo order was granted, and still, my lord, say 2020, my lord, suit number is 90 of 2020. Still date.
This application under Article 227 of the Constitution.
My lord, I appear on behalf of the opposite party, my lord. I am on caveat, my lord.
Yes. Yes, Chatterjee, what do you want?
I appear on behalf of the plaintiff appellant petitioner, your lordship. My temporary injunction was rejected.
Temporary rejected.
Temporary rejected in misappeal. Ad interim refused. I have come up before your lordship.
I'm expediting the hearing of the
So
miscellaneous appeal.
only thing because
Temporary hearing, Mr. Chatterjee, no ad interim.
no, I'll not take much of your lordship's time. I will just place 2-3 pages and the impugned order of the trial court. Nothing more than that. Only your lordship kindly sees page 56, my deed. Just the subject matter of the of my suit, page 56, volume 1.
Yes.
Lordship kindly sees. On the east, your lordship has
Page 56.
page 56. On the east, there is a 16 feet wide road.
Yes.
My contention in the plaint is that this is a common passage. There are 9 plot holders who use this passage as a common passage. The defendant number 1, her case is that along with the local peoples, this is not a private passage of only the 9 plot holders, but she also has a right as a common, because this is a common KMC road. That is the only bone of contention.
They say this is the KMC road.
KMC road. Admittedly, common passage. We say exclusive to 9. She says local people can use it, whoever may want. That is the only difference between the two submissions. Now, your lordship kindly sees the map at page 62. This is a rough map from which your lordship will get a clear idea. Page 62.
Yes. Now, what is
portion is the common passage. This is the dispute. The defendant number 1 is 38B BC Road. So she has a small opening there.
Defendant is the
38B BC Road, the lower
38B,
portion.
yes.
Yes, and the plaintiff is 46/9 adjacent.
Yes.
Just above that. Now, all these 46/1, 2, 3, 4, 5, 6 to 9, they use this. This is their claim that this is the common passage, their private access. Now, your lordship, I will take your lordship to the ad interim order where I was granted ad interim. That is volume 2, page 140, the second page of that volume. Page 142 is the ordering portion of my ad interim order. The defendant number 1 is restrained from dumping any material in the private passage and to create any obstruction in free ingress and egress of the plaintiff in the common passage, that is B schedule property. B schedule was a passage as on date till 5/11/24. This was admittedly extended till my refusal in the temporary injunction application. Now, your lordship kindly sees their objection, because I must place that. That is at page 212. Your Lordship kindly sees page 214. I am placing from the top. This is a continuation of a line. Anyway, when your petitioner has obtained the sanction plan, wherein also has shown the KMC passage, alleged private passage for ingress and for egress and ingress of your petitioner. After obtaining the sanction building plan, your petitioner has started construction work of her premises. As such, your petitioner and her masons and laborers have had been using the said KMC passage for their egress and ingress at her land. After looking the same, the pro forma defendants have started obstruction.
Where is your injunction application?
Injunction application at part volume 1. From that, I have placed the deed. Your Lordship.
Where is the prayer?
Prayer, Your Lordship. Prayer is at page 33. Many things are there. Page 34 is the relevant portion. I have prayed for access, restraining from access, creating any entrance, but
that cannot be done.
No, I'm not praying for those.
What are you praying now?
Only what was given to me in the ad interim injunction. Only because admittedly it is for the common people, whether
No, ad interim
for not to dump, because in the what happened in the temporary injunction, there are conditions where the learned trial court. Your Lordship, kindly may I place the the order, the rejection of my temporary injunction. Kindly seize. Order dated 1st of July 2026, the second volume. Your Lordship, kindly seize. Only the last portion of my prayer is that dumping any material and creating any obstruction in the free ingress and egress. In the middle portion of page 34, the Lordship will find. And
what is the temporary injunction order?
Yes, that is dated 1st of July. Your Lordship will find from volume 2, the certified.
Yes,
copy.
yes.
The second.
How are you affected by this?
Yes.
How are you affected by this?
This has been rejected, Your Lordship.
Where?
Rejected, and only the conditions imposed are that she will not raise any construction except
that is what I am saying.
No,
rejected with some observations. How are you affected?
Yes, because
this will protect the interest of both.
No,
I direct the
Your Lordship kindly considers this. If it is only saying that no permanent encroachment be done.
Yes.
If they dump it for a temporary period, my ingress and egress, because I am only the adjacent plot holder.
Sir, if they dump,
there is
if they dump, they will also not be able to access. So
no,
they cannot dump.
They have a different, because this was on their backside. They are protecting their
sketch map. Sketch map does not show.
Kindly seize their deeds. Their deeds kindly.
Sketch map does not show any.
I do not want Your Lordship to go into that. There are Your Lordship.
Sir, Chatterjee, this appeal. So when is the next date fixed? I direct the miscellaneous appeal. Otherwise, Mr. Chatterjee, can it be modified in this way?
I'm not.
What remains?
Modification. I'm not praying because
has to be modified because an interim.
Rejected. Your Lordship kindly considers my 3912 has been rejected and they are vacating.
No, some observation rejected. I can clarify. Rejected, though the word rejected has been made, but a restraint order has also been passed.
From 2024, I was enjoying this order of ad interim injunction. They were raising construction. It was not that because in their written objection they say that they were raising obstruction. There was no difficulty. They can access that. They can come in. They can put their materials in their property. They can raise construction. Only two things were that my ingress and egress should not be obstructed, and they cannot dump it on the common passage. It is admittedly a common passage, whether for 9 plot holders or for 50. That is not that can be decided in trial, but today,
all right, I'm coming after 5 minutes.
Okay.
Yes.
Kindly seize the impugned order of the trial.
Yes.
The reasoning for overturning my ad interim injunction. Second page, points for determination, it starts. There are 3 points: prima facie case, balance of convenience, and irreparable injury. The prima facie case, the court says that there is a triable issue. So I also say, yes, there is a triable issue, whether it is a private passage of 9 persons or the local people, common passage. Now, the second point, balance of convenience and inconvenience. May I place? The materials on record disclose that defendant number 1 has obtained a sanctioned building plan from competent municipal authority and has commenced construction. If the injunction is continued, the construction activity would remain stalled, whereas the rights asserted by the plaintiff are yet to be adjudicated. This was not the ad interim. So construction was never stalled. So this reasoning is, in my respectful submission, bad. Now, irreparable injury, the plaintiff has not demonstrated that refusal of temporary injunction would result in irreparable injury incapable of being compensated or adequately addressed. Conversely, continuing of the injunction is likely to cause substantial prejudice to defendant number 1 by preventing use of access. Use of access was also not there in the ad interim injunction, only with regard to dumping and obstructing the ingress and egress of the plaintiff, the petition. So, on the basis of these reasonings, the court comes to a finding that yes, order 39 rule 1 and 2 injunction application has to be rejected. But these were never, the defendant number 1, opposite party number 1 was never restrained from these. She can access, she can construct.
So your only grievance is with regard to dumping.
Dumping, and as a corollary, my ingress and egress should not be obstructed. That is the only my contention, because
your ingress and egress will be obstructed by way of dumping.
Yes,
otherwise not
that is why I'm saying, as a corollary.
So far this dumping is concerned, there was no dumping. Rather, on contrary, it's a factual finding, my lord. May I place it? They keep one car there in order to create an obstruction. My lord, this is there. If my learned friend has referred to this, my lord, lordship, kindly come to page 238.
Is it your case in the written objection? Is that they are keeping a car?
My lord, in the written objection, my lord, if your lordship kindly come to my application 238, that is the
application for
the under order 39 rule 4.
Order 39 rule 4. All right, vacating.
If your lordship kindly come
238.
238, my lord. The temporary injunction restraining defendant number 1 is main agents accessing, using, entering into the Schedule B property and creating any entrance gate from Schedule B property, and also from disturbing peaceful possession and enjoyment of the suit property, and also restraining the defendant number 1 from dumping any materials in the private passage, creating obstruction in free egress and ingress of the plaintiff. After considering the application, learned court was being pleased to pass an order dated 5/10/2024. The defendant number 1 is restrained from dumping. Thereafter, my lord, that Schedule B property is recorded as passage part of Kolkata Municipal Corporation, which is being used by the neighboring people, including your petitioner, defendant number 1. That your petitioner states that as and when your petitioner has started construction at his land, since then, out of greed, the pro forma defendants have been creating the obstruction to use the said KMC passage path. As such, several complaints have lodged from both the sides and several criminal litigations are pending between the parties. Already, FIR was lodged against the pro forma defendants by defendant number 1. Your petition and the charge sheet will be placed in that such and such. The petitioner was under impression that the pro forma defendant may file civil litigation along with the temporary injunction against your petitioner relating to the said suit property or disputed passage path, for which your petitioner time to time has lodged caveats against the pro forma defendants, and last of which was filed on such and such date. Your petitioner states...
What is your allegation that they are keeping cars? You have not stated that in the
allegation is not there. There are the complaints, counter complaints pending.
That's neither here nor there, Mr. Chatterjee. You have not stated that,
kindly
they are obstructing.
Only one thing, my lord, page number 212 once.
212, yes.
This is my written objection.
Yes.
Here, my lord, kindly come to page 213. last paragraph, it states that since purchased a property, the members have been using KMC passage and no one never raised any question. At the same time, purchase of the land after taking the local inspection revealed from the site plan, deed of conveyance, as obtain the sanctioned building plan where KMC passage and for egress and ingress of your petition. After obtaining the sanctioned building plan, this was done. My lord, I have given it. Then, my lord, kindly come to 19. 219. Your petitioner states that petitioner have common right to enjoy common passage path. Said alleged private passage is a KMC passage which is meant for all of the local people, including the defendant number 1. As such, neither the plaintiff nor the pro forma defendants have any right to raise any question of obstruction to the enjoyment of the petitioner's B scheduled property in KMC passage path from the photographs. It will be clear enough to the plaintiff have been creating obstruction for egress of the KMC passage by putting a card with the intent to blockade the KMC. So it is there, my lord, the objection. And the photograph is annexed in page 222. That is my case.
223.
23 also.
If my learned senior friend goes
This is a car.
travel, yes, because this was, if your lordship now sees their deeds, your lordship, I have indicated that this is a 16-feet passage. So lordship, from that
no.
your lordship,
You also cannot block this passage.
not blocking. This is
Whose car is this?
I do not know. This is in front of my house. Your lordship, kindly sees page.
Maybe,
62.
but this is on the
Page
passage.
62. Once.
Mr. Chatterjee, this is on the passage. This is also on the passage.
Kindly sees page 62 once. This is not their application. Kindly sees page 62 once.
Yes.
Volume 1.
Yes.
Now, this is a 16-feet wide road.
So, according to you, keeping of the car will not block.
It is not in front of their property. That is in front of my property.
Maybe in the portion, passage is not your property, Mr. Chatterjee.
No,
passage is not on the property. So the car is on the passage.
On the road,
so you are obstructing.
222.
So, is it your case that they are dumping materials in front of your property? That's also in the passage.
Yes.
Please show me that in the front of your property. Do you have any materials to show?
Kindly sees volume.
Do you have any materials, any photographs?
Yes, yes, page 137,
Yes.
volume 1, the last 3 pages, your lordship kindly sees. This was my injunction application.
Yes.
Recently, at the time of filing of this injunction application, they have recently demolished this wall and the debris are there. Your lordship kindly sees page 137.
Mr. Chatterjee, these debris, they will be.
No, this was at the time of filing of the injunction application. Your lordship kindly considers now they are raising the construction.
Yes.
And so obviously the materials are much bigger in quantity. Now your lordship kindly sees.
So do you have any? These are debris. Do you have any material photographs to show that the building materials have been accumulated on the passage?
They could not. They could not because I had an ad interim injunction restricting them from dumping.
I could not because of the car.
Now, what is the stage of construction?
Now they have probably first floor is being constructed. Your lordship.
Yes, Mr. Chatterjee, what is the
We
stage of
have
the...
already constructed the first floor and almost we cannot access to that gate, my lord. That is creating a trouble for us, so that we had to file the caveats and all. My lord, I will take the instruction, the latest position of the construction, my lord.
Yes.
Today
But you
only
cannot, Mr. Chatterjee, you cannot also dump the
I
building
don't want to
materials
dump.
on...
I don't want to dump.
So,
My lord, let there be the undertaking by them. They will also not keep the car. I will.
What do you say?
I am not going to dump anything.
That is not.
Nobody is going to.
Mr. Chatterjee, yes, you have also to undertake that you will not keep cars. Otherwise, I will send it to the appellate court. Let the appellate court decide.
But your lordship kindly considers the common passage.
Mr. Chatterjee, this shows that you are blocking.
No, I am not blocking. But
So
your
why
lordship
are you-
kindly considers the
Why are you
passage
not
as-
giving your undertaking that you will not be keeping cars?
I can. If your lordship, I have to
So
take
file
instruction that
an
first
affidavit that you will not be keeping cars on the passage.
Your lordship, since your lordship is asking me to take instruction with regard to the passage. Now the passage is a long.
Maybe, but you cannot block the passage. 16 feet, you can say, I'm keeping car on 8 feet.
No,
8 feet is there. No.
It is your lordship kindly sees the plaintiff and the
That's
proforma.
not the parking space, Mr. Chatterjee.
May I just make one submission, your lordship? The plaintiff and the proforma
Or
defendant.
I leave it open to the appellate court to decide.
I'm not going into that. The plaintiff and the proforma defendants, they are the plot holders of 9 plots. That is their common passage. That is our case. Now, if your lordship says the entire common passage, I cannot park. I'm not the only person. The difficulty, your lordship kindly consider. It is not. It is not that I am only parking my car in that common passage. If now your lordship says that his portion,
So
his
according
access,
to you, others are also parking.
maybe. Now, I have to take instruction because I am the plaintiff in this, others are not. Now, if your lordship directs that his access to his property will not be blocked by my car, I can give that
Not he's there. So I can also say that he will be keeping garbage, not obstructing your gate.
Yes, he can.
Not obstructing. That's not your prayer.
That is only my prayer.
That was
is
not
that-
the ad interim injunction either.
Yes, ingress and egress of the plaintiff only. He can dump before the proforma defendants. I don't mind. But your lordship
Please
kindly
show me.
consider-
Please show me
and
the.
their deeds, if your lordship kindly
No, no.
sees-
Please show me the ad interim order of injunction.
Yes, yes. Page 139. 139. Your lordship kindly sees. Page 142 is the ordering portion.
Yes.
42. That the defendant number 1 is restrained from dumping any materials in the private passage and to create any obstruction
Yes, in the private passage.
Yes, that is with regard to dumping
And to create any obstruction. So dumping is the private passage is for all.
Then I have to
Private
take
passage is
instruction.
for.
I have to take instruction. Whose
You have to
car
take
is that?
instructions then.
Maybe his car. I do not know. I have to take instruction.
him
And
reply.
I will come. That is probably his car. And
That is probably his car.
Maybe.
He will give a photograph and annex that in the written objection.
I do. Because your lordship will see their deeds. Their deeds. Kindly seize their deeds, your lordship. Only once for my satisfaction. So lordship,
What is the stage in the miscellaneous appeal? Instead of going to that, I
Only
give you
September is being filed because then if your lordship
9th September.
if your lordship continues this ad interim injunction, then the
What remains to be decided in the miscellaneous appeal?
Yes, there is nothing.
No. That cannot be done.
Your lordship kindly sees 2 pages, 2 deeds and their schedules I will place of their property from which they have purchased.
Mr. Chatterjee, it's better you go before the appellate court. There is,
Nothing because
I cannot dispose.
In the meantime, I will not be able to access my front.
It's your, Mr. Chatterjee, it's your miscellaneous appeal.
Because
It's your miscellaneous appeal.
Without this ad interim, this injunction of dumping, because
I
they will-
ensure, my lord,
they are-
he will,
Mr. Chatterjee,
his access
it's
will not
well
be
settled now.
blocked
If there is
by
an refusal to pass an injunction in the miscellaneous appeal, there is no scope to pass any ad interim order of injunction.
I understand.
So
I
the
would
best
not
thing
have
is
come.
that they have to be
I would not have approached your lordships. Only reason is that if the ad interim injunction is continued, they will also not be prejudiced because they were raising construction. They were raising construction from 2024.
They want some injunction against you also.
Your
They
lordship,
want some
they have not
injunction
prayed
against
for
you.
that. They have not prayed for that. They have not filed any suit.
All
From
right, then
October
I go-
2024, they have been.
I go by those
This
principles.
was existing till July 2026. Your
Sir,
lordship, kindly
Mr.
consider.
Chatterjee, they have to be given an opportunity of hearing.
Granted, they have used their objection to the suit
in the appeal, Mr. Chatterjee.
Your
So on a
lordship, nothing
contest, Mr. Chatterjee, please understand. On a contested hearing, this prayer has been refused. So now ad interim, this will be allowed. What are you saying?
I'm not saying that. I'm saying your lordship kindly modifies because
No,
there are 2 restrictions.
modifiers
already.
at the ad interim stage cannot be done.
Not in the ad interim, in the temporary injunction, if your lordship kindly.
Chatterjee, now it's the ad interim of the miscellaneous appeal. Please understand this.
Lordship, kindly
Because your appeal is pending.
If your lordship modifies the ad interim, it will automatically change.
No.
Lordship, kindly take page 236 once, my lord.
This is taking, Mr. Chatterjee, this is taking a forum of appeal. I cannot decide overstepping that appellate forum.
Well, kindly come to page 236 once, my lord. One paragraph I want to show you, lords. Page paragraph
We
number.
agree to a joint thing, file an
May I
affidavit.
come back tomorrow because I will take instruction with regard to the part.
Also, so far the dumping and the car is concerned.
Yes,
my lord, kindly.
both.
Lordship, kindly come to page 236 once.
After some argument, Mr. Chatterjee
Yes, but I'm not putting it.
25, yes.
But I'm the tenant, madam. I am. My position was taken by the finance company through policial panel on the 3 years back.
You are the tenant.
Yes, my lord.
What do you want?
But as early as possible, the matter be expedited. Otherwise, I am out of position, and this is my livelihood, my lord.
DRT.
Yes, my dear. This is my livelihood, my lord.
No. What do you want?
And the expedient hearing of the application.
Sir, it's difficult. How many debts recovery tribunal are functioning?
My lord, 2 years.
Sir, how many debts recovery tribunal are functioning? This is already a transfer application. So from the original tribunal. Again, that expeditious. It's difficult. It's difficult, sir. It will be putting too much of pressure. Transfer court, how can it be decide the main proceedings?
Transfer if all the appeal has been transferred to DRT3.
That is what I am telling you. So how it's possible to manage? Is it possible? This application under Article 227 of the
I'm good with you.
Lord, I beg your way for the petition. Let
Yes.
me petition. My lord, a partition suit. I have filed a partition suit, my lord. My lord, subsequently, we have filed an application in that suit for because our claim is that, my claim is that the entire property is a single property having notional sites like southern part and western part, and it's a huge property. But the entire property is same as so for the building is concerned. However, on the contrary, the defendants, they are totally disagreeing in seeing that there are two buildings. Now, my lord, we have filed an application for appointment of an advocate to be a local commission so that this thing can be solved.
Where is the plaint?
Just 1 minute.
What share you have claimed? You have not claimed any share.
In 1/20th share of it.
Where is that? Where have you stated?
My lord, can you
Southern portion of the suit property, northern portion of the suit property, 1/20th share. Yes, you have said southern, northern. So what is the difficulty?
these are notional, the building is same.
Yes.
Let the building be same. We have now
Now, why do you want this local investigation? For what purpose?
single purpose, my lord, so that the local inspection may kindly visit the property and see that the property is a single property.
For what? What is the difficulty now? What is the dispute now?
Dispute is, my lord, the learned court is now wants to make it a preliminary degree.
Yeah, so preliminary degree will shares will only be declared. So if it is a composite, it's composite. If it's a different,
Understand, my lord, let this single thing.
no, no, no,
My
not
lord,
now. What has been done?
let them serve and come, my lord.
You see, what is the order?
Order, my lord. My lord, if I may read the third paragraph of the order, this 85, page number 85. After hearing both the sides and perusal of material on record, it appears from the schedule C of the application that
Yes, as observed rightly. At this stage, there is no necessity.
Exactly.
So in the final degree proceedings, commissioner has to be appointed. So
understand,
then the commissioner will go and demarcate single building, different building.
my lord, let me serve back and serve and come.
This application under this.
My lord, when
I appear for the petitioner before your lordship. Now, the bank is the petitioner before your lordship, but I am essentially praying for expeditious disposal of my Order 7 Rule 11 petition pending before the 13th bench of the City Civil Court. But I'll just give you the brief background of the case.
Order 7 Rule 11.
Order 7 Rule 11. Now, my lord,
You are the defendant.
no, yes, I am the defendant in the suit.
The written objection has been filed.
No, it has not been filed. My lord. We have just been served with a summons. My lord. What has happened is that the section 14(1) application is pending before the district magistrate. Now, my lord, this application was made in October 2020.
Pending before
the SARFAESI Act, my lord, before the district magistrate. Now,
Yes.
now, my lord, there was an order passed by the coordinate bench of this honorable court directing the district magistrate to dispose of the application within 4 weeks. Now, my lord, we approached the district magistrate. We found, my lord, there's a suit pending and an injunction subsisting. My lord, we took out an application in that suit, same parties involved, my lord, State Bank of India and GB Logs. We took out that application. That application was allowed. Claim was
under Article
rejected.
220. Yes.
Item number 28, I appear on behalf of the petitioners. I pray for a nod today, Your Lordship.
Please don't pray for not today. Please move this. What is this matter?
Your Lordship, I'm being led by a senior in this matter. And
Who is your senior?
Mr. Aman Agarwal. He's on his legs.
The learned advocate. Yes.
My lord, my lord, kindly come to the last page, last order, my lord, order dated 18 July 112. My lord, I prayed for an adjournment. I prayed for an adjournment by filing an application on the ground that my earlier revisional application is pending before my lord. CO number 37 of 2025 is the monthly list. That adjournment petition was rejected, and in view of the attendance circumstances, considering the age of the suit, the prayer for adjournment of the petition is considered rejected 25th August 2020. I have mentioned before my lord on 13th, my lord, and my lord was pleased to allow my prayer for upgradation, but since my lord 14th, my lord was presiding over in the Jalpaiguri bench, that is why my lord I could not be upgraded. My lord. That is why my lord
It is appearing in the monthly list.
it was appearing in the monthly list, my lord.
Now it is not appearing.
My lord, because my
It is
lord,
appearing or not appearing. Now it is appearing in the monthly list.
today, my lord, it is in this monthly list. It is not appearing because I mentioned before my lord Justice Rai, and my lord Justice Rai was pleased to direct the to call for the records. And thereafter, it was not updated, and my lord's officer has said that it will not be
It
again.
has gone down to the department.
My lord, I beseech your lordship to.
In that civil division application, what have you challenged?
My lord, I have challenged the amendment application which was rejected, my lord.
You are the plaintiff.
And I am the plaintiff.
What stage?
At the stage of argument, my lord. At the stage of argument, my lord, and if my lord, my lord will kindly see, my lord, I have annexed it, and I'm handing up the certified copy. They have admitted the entire plain case. They have
You can go by the admission, Mr. Banerjee.
My lord, they have left the blank, the plot number blank. My lord, kindly see paragraph.
What is
11.
where is the application for amendment? Please show me.
My lord, kindly see my lord, annexed B, my lord. Paragraph 11, my lord. They have admitted.
No, please show me your amendment application.
My amendment application. My amendment
yes.
application is at page 44, my lord. Paragraph 11, they have admitted anything, leaving my share plot number blank. And that is why I wanted to amend there for partition suit. They are on partition of the co-scheduled property. They have said that I have 1/3 share. But has left the. I beseech your lordship to list both the matters at any convenient date upon service to the opposite party, my lord. And in the meantime, my lord, some interim order may be passed. capriciously they had left blank in the written statement, my lord. Otherwise, my entire plain case has been admitted. It is for the entire release, and you will prevent multiplicity of suit.
In that, Mr. Banerjee, is there any caveat in the other matter?
No, my lord, they are not appearing. They are opposing there. In the trial court, before the trial court, they are not filing any
So,
caveat.
have they filed any caveat? What is the CO number? What is the CO number?
CO 37 of 2025. It was appearing in the monthly list of July as item number, before my lord, 1394. I'm grateful, my lord.
Yes.
I am opposing this application.
Yes.
Number 15.
Yes. The petitioner said that your application under section 7(1) was time barred. If that is so, what remains?
Lordship, it is not time barred because the entire.
Show me
Yes,
when the summons was served, when you have entered appearance, when you deposited this amount.
Lordship, the rent was deposited in advance. 1 year in advance was deposited. So the 7172 was only for this limited scope that whether the rent which was deposited in advance would.
So please show me when the summons was served.
Lordship. That. Your Lordship will kindly take the impugned order. It's all given in the impugned order. 5/10/2023, the defendant had entered appearance.
5/10/2023.
The defendant had entered appearance.
Yes.
Lordship, prior thereto, there was a publication in the newspaper. The plaint was not served. We entered appearance and we asked for a copy of the plaint. It was subsequently served. 16th December 2023, the defendant was served with a copy of the plaint. 2nd January 2024, the petitioner filed his application under 7(1). These are the relevant dates.
And when you filed this application under
2nd January 2020.
Mr. Rai, this is to be hard. This is to be hard.
Okay, submit one thing.
This is to be hard, or if you say you will not proceed, I can expedite the suit.
Oh,
I can expedite the suit, or then it is to be hard.
as well as let it be hard because I want disposal of the revisional application, 7-2 application is pending. The limitation point has been sought by the learned trial court. So it will be considered at the time of hearing of the 7-2 whether it is part by limitation or not, because whatever the amount they are depositing, 7-1 without prejudice, the first part of the order says that
So 7-2 hearing is fixed.
is fixed. So including the point of limitation,
If your
it
lord,
will serve the purpose. Let me submit, my lord, kindly come to the very findings. Thereafter, on the same day, 5th of October 23, the defendant appeared and filed a petition with a prayer for direction. And he filed the application on 2nd of January. The language in the statute is otherwise. If
No, the court has held that 7-1 and 7-2 are not barred by limitation.
yes. So that point should be decided. The court has already decided that this is not part by limitation. And the language of section 7-1 is something else. 7-1B. Such payment or deposit shall be made within 1 month of the service of summons. Let me accept that no summons was served on the tenant or where he appears in the suit without the summons being served upon him within 1 month of his appearance. So I am harping on this line. Suppose, let me accept, if I accept that the summons was not served, they appeared on 5th of October, without the summons being served, they got the notice that the suit has been instituted, summons being served within 1 month of his appearance. Sir, is there any scope for extension?
Mr. Rai, only one thing. Without the admittedly, when the newspaper publication was published, plaint was not served. So the summons was not served in ordinary course. It could not be proved. Now he entered appearance. So section 7-1 says that the areas are to be admitted, areas are to be deposited, or if there is a dispute 7-2, unless the copy of the plaint is served. So this time limit will start from the date of the appearance or from the service of summons. Now, if you want to, you are the plaintiff. If you want that this point is to be decided, then I have to decide that. Or if you go without the,
I am on the simple language of subsection B.
I can decide on that, Mr. Rai. You are the plaintiff. But choice is yours. Choice is yours. I can.
One thing, but since the 7-2 application is pending, whatever the amount they have deposited, that is without penalties. So this limitation
has to
point,
be.
So the limitation point will be considered.
No. Limitation has been held in their favor. That if you want that, I will decide this.
Yes. Then, my lord, kindly fix a date for hearing, because I will not give up this point of limitation. As per my instruction, because of the language in the statute, within 1 month of the appearance, there is no mention.
Do you have any authority in your support in a case where the summons is sought to newspaper publication?
Matter, I believe I have lost. I will find out that judgment that I took the same point. That I appeared on the basis of the information sheet without commons until and unless the newspaper or the summon is served, the copy of the print.
You lost, so you cannot lose again. Twice you cannot lose.
So let me come back with the findings of our court.
After hearing the learned advocate for the yes.
Petitioner is a non-banking financial corporation. It's Cholamandalam.
Petitioner is a
NBFC, my lord.
Yes.
My lord, only one inopposed prayer, my lord. The next date has been fixed on 13/8/2026. My lord.
For what?
For my lord, for disposal of ad interim application, my lord. Application under Order 39 Rule 1 and 2. Application under Order 39 Rule 4 also, my lord. My lord, only one.
Expeditious hearing.
My lord, suit was filed on 22/7/2026.
This application under Article 2, you Yes, what happened? What are you challenging?
But this the petitioner has made a payment of 1 lakh on the initial date on 14/1/2020, my lord, and the landed court allowed that amount to be paid, and the landed court had directed to make the further payment within a stipulated period of 3 months in the year 2020, my lord. And thereafter, my lord, due to the COVID, my lord, this amount could not be paid at that time, and before the last date, the entire constitutional money was paid. But at that time, it was rejected only on the ground that entire consideration was not paid in initial stage. So appeal was allowed, and appeal was also same ground. This is the order passed by the landed junior tradition, my lord. Order that meets appeal.
When you filed the preemption application?
But it was filed on 14/1/2020, my lord, by payment.
14/1/2020.
Yes, my lord. This is certified copy, my lord. This is the order. This is the application. This is the application of section 8 and 9. Subject affidavit. The danger challan in duplicate allowance.
No, in time and on 40 and on. No, on 2 dates. 5/1/2021, you have deposited the next.
Yes, because my lord, on 2020, I have filed 1 lakh, and then next date is given within a short time of 3 months. Then the COVID had started, my lord, so that amount could not be paid. And before the last date, entire constitution money was paid. And on 5/1/2021, that's immediately after the COVID, it was not so much strong. The petitioner made prayer to deposit the amount, and the entire amount is paid. That is the paragraph 5 of the petition, my lord. Then, by subsequent order on 3/12/2021, the landed court, my lord Benjamin Ground, rejected the same. But this is not on letters on the part of the petitioner, because on the prayer, he made the prayer that prayer is allowed the landed court. Someone like certain time has been given to report the amount. Then the COVID is within the releasing period. So immediately after the COVID is to some extent over, he made the payment. There is no letter on the part of the petitioner, nor there is any dispute regarding the amount to be paid. I'll judge, my lord. This is the separate copy of the landed trial judgment, accepting my prayer and allowing to deposit the sum of 25 lakhs.
You are a non-notified court sharer. Are you claiming non-notified court sharer? No, you are sought for preemption under what ground? Only
This application I have annexed also, my lord.
adjoining owner,
Yes, adjoining owner.
not on the ground of co-sharership.
No. Adjoining owner. The application is also annexed, my lord.
Then it's
So this is
difficult.
regarding the self-consideration. I have made the payment that is accepted by the landed charges, and even the balance amount that is paid that is also accepted by the landed charges.
Certified copy.
But this deposit was beyond time.
Because due to COVID, that
No, COVID benefit you will not be getting because the period of limitation expired long before. So benefit of the Supreme Court order of in the suo motu case you will be getting if the period of limitation fell between that. Your period of limitation, you are a adjoining owner.
But from 2020 March until 21, there is a winter period.
So prior to that, the limitation period expired.
No, my lord. Subject by submission, my lord. that-
Why? What was the when the period of limitation expired? In your case,
My case within the year 2020 for 3 months, my lord, time is given. But when this on 5th June 2021, when this
what would be the last date for filing of the preemption application in this case, according to you?
the prayer is initially, my lord, the order was passed to run 3 months.
So don't go by the order. I'm asking you what would be the period of limitation for filing of the application. Please forget about deposit of the amount now.
3 months from the date.
Yes. So when?
Within the year 2020.
What is the date?
Well, that is on
14/1/2020 you filed. What would be the last date? What was the date of transfer? September 2019. So you'll be getting 4 months. October, November, December, January. So the period of limitation was from March. How you will get the benefit of the Supreme Court order?
But when I deposited the money in the month of January.
Sir, you are not.
Yes, madam. But
Have you seen the judgment of Barasat Eye Hospital?
yes, but there, my lord, there is
So if it is, you have to deposit the amount. Even the court cannot extend that.
yes, but there, my lord, Indian amount to be decided, paid that
So you ought to have deposited January, within January. So on January, this benefit, because September was the date of transfer. You will be getting 4 months. You are an adjoining owner. Your case is not that of a non-notified co-sharer.
But yes, madam, but I have deposited in the month of January of 2020.
Sir, court has extended. Court could not have. That's the difficulty.
Because, madam, for the case.
Sir, have you read the judgment? If you have read, then what's the proposition laid down there? Whether court can extend.
No, madam.
Then here, so the benefit of the order of the court, I'm not that, according to you, the court permitted you to deposit within a certain time. You deposited after that due to COVID. Even that court could not extend. What can be done? What can be done?
Certain beliefs should be done because, my lord, the poor litigant, they are not aware of this judgment or anything, my lord. the petitioner is not aware of this violation of judgment, my lord. So he has made the deposit and there is no order to that by the arbitrary judge. And the balance amount was allowed to
You have the judgment of Barasat Eye Hospital with you. That was free.
But there, my lord, there is a dispute against
Mr. Mukherjee, when the Barasat Eye Hospital was passed,
19.
what is the date?
October
The date of passing of the judgment.
October 19.
October 19.
But I am not sure, my lord.
Yours is of January 2020. So it's March.
Because let down new law, it's not there, it's the law which was there explained by law. That's also.
But this was on 17th October 2019. Barasat Eye Hospital.
17th October, Barasat Eye Hospital. Even then you are worse off. Yes.
Let the learned trial judge decide the matter as expeditiously as possible. I understand the constraints of the learned trial judge because they are sometimes at times transferred. There are resolution.
What is the proceeding which is pending?
Madam?
What proceeding is pending?
Land acquisition proceeding being LRA number 53 of 2003 within bracket capital V. Pending before the learned additional district judge with court at Calcutta. I was simply praying before the Lordship that the Lordship may not specifically, but the Lordship can direct the learned judge to
This application under Article 227 of is there. Yes. Yes.
For partition, during final degree proceedings, my lord, one of the possessor has died. Application for substitution was filed, but it was not disposed of. My lord, the decree was passed in that way. And my lord,
Decree, final degree passed.
my lord, thereafter execution proceeding was initiated. I filed objection that it cannot be proceeded with because the decree is against a dead person. My lord, they filed an application for substitution in the execution proceeding, but that has been allowed. That cannot. It is required to be remanded back to the court where my
Mr. Mahato, you said that a substitution application was filed.
but it was not allowed, it was not disposed of.
No. So, where is the question of abatement then?
Well, so for partition suit, there is no question of
No. Even if it is,
abatement.
so if it is not if there is no question of abatement, there is no question holding that the decree is nullity.
No, my lord, my submission is, my lord, the executing court
There's no
cannot go
necessity.
beyond the
Only
decree.
correction of the amendment of the decree. It's not nullity.
My lord, I am relying. My lord,
It's not nullity, Mr. Mahato.
question of nullity. My lord, I am not saying that nullity.
Only the decree will be corrected. I will direct the final decree, the records to be corrected. Execution
By the court, not by the executing court.
by the court, only the records will be corrected, Mr.
It is well settled, my lord. My lord,
What well settled?
well, sir, it is required to be remanded back.
No.
Application for
Sir,
substitution.
Mahato, it's well settled from 70 Calcutta, page 99. If there is abatement, if the application for substitution is filed within time, the court does not dispose of, proceedings cannot abate. I'm bound by my own decision. I've considered this. In Port Blair bench, I've delivered a judgment.
But I am not raising the point of abatement because it is arising
Mr.
of a
Mahato.
partition suit.
Yes, Mr. Mahato.
Abate question of abatement is not there, but it is required to be regularized.
Yes, regularized. For that only.
Required to be remanded back.
For what?
The final degree is required to be reopened.
Reopened to the extent of?
No, my lord.
Again, fresh hearing.
Yes.
No,
Please show me.
file.
Please show me the authority, Mr. Mahato.
Yes, my lord, I shall come back, my lord. I disposed of in first appeal, my lord.
Which judgment you are referring to? 70 Calcutta, page 99.
Relying that, my lord, Justice Jyotirmoy Bhattacharya disposed of a first appeal, remanded back before the trial court for.
Mr. Mahato, I am again telling you, there is a distinction between non-filing of an application within the specified time frame and filing of a substitution application. Court do not dispose of it. If it is not disposed of, application is filed, cannot abate.
But application is, my lord, question of abatement does not arise.
Mr. Then, the decisions which you are relying upon are all on abatement.
Kindly take it up tomorrow.
My lord, I already filed. It is recorded my name.
It corrected decree,
No.
Not decree corrected, that corrected my execution application.
not the execution application.
Execution petition,
the
in
final
the execution
degree.
proceeding, he filed the application for substitution. That has been allowed by the impugner.
My lord, I
Execution substitution is not necessary also.
Therefore, my lord,
Then substitution is not necessary. Only the heirs are to be brought on
my lord,
record.
final degree proceeding is required to be reopened. Final degree proceeding is required to be reopened. My lord, I shall come back tomorrow. Mr. Pawal Mukherjee was against me in that decision.
Mr. Mahato, I'm again telling you, there's a distinction. There is two things.
Filing and non-filing.
Yes, because all those line of decisions which you are telling, but now I am telling you the situation is otherwise. So now the Supreme Court has said otherwise, even without going to that. Now, what is the, when does a proceeding abate? Let us forget about the preemption proceedings. Let us forget that it is not a preemption proceeding, partition suit proceedings. Let us take it an ordinary proceedings, which abates for non-filing of a substitution application.
And it is not the preliminary degree, final degree. Therefore,
I am asking you, forget about it's a partition suit. Take an ordinary suit. Let us not go into that final degree. Let us say in the suit proceedings, now a person dies. Now abatement will occur when? If within 90 days the substitution application is not filed. That's the expression used. So if it is filed, there cannot be any abatement. Now it's the duty of the court to take up that application. Let us assume it has been filed on the 80th day and it has been taken up after 3 years. So can you say it has abated? No. So it's the court's fault. So in the meantime, if that application is also on record and the court passes a decree in the name, maybe in the name of a dead person, can you say that decree is nullity? I'm on that proposition. Mr. Mahato, you have to enlighten me on that. Even on that, the proceedings can be decreased the nullity. Please consult, because I have also delivered a judgment, not in this, before the Port Blair bench, delivered purely on that. The application was on record, and here you are admitting that the substitution application was filed. That's within time. So if that is within time, but the only fact is that the court do not allow that.
Yes, sir, required to be, my lord, added, my lord, allotment of the property should be in their presence. My lord, these are the regular procedure.
So allotment is, it will be going to the heirs.
Yes.
So it has been allotted in the name of the predecessor.
In their presence.
In their
Should be in their presence.
You are not for them. They are not aggrieved.
But procedure.
You are not for them. They are not aggrieved. Sir, Mahato, the issue that arises for consideration is whether (34) pass over next.
Lordship, argument 35, I'm appearing on behalf of the petitioner. It is my application for expeditious disposal, Lordship, ejectment suit of 2021, Lordship. The Order 6 Rule 17 is pending. 7172 disposed of in 2025.
You want expeditious disposal of what? Order 6 rule 17.
Lordship, the suit itself, the whole suit itself, because
Order 6 rule 17 disposed of.
or no, it's pending,
This
Lordship.
application under Article 227 of the Constitution of India is
For the petitioner, well, I am the defendant in a commercial suit that the issue is with regard to one of improper service of writ of summons. Plaint was served along with the writ of summons, but one of the
then what happened?
But then, but my time to file the written statement, which is mandatorily to be filed within 120 days, that expired. I still affirmed the written statement and filed for acceptance of my written statement on the ground.
Within time, out of time, how can it be accepted?
But my time to start time to file written statement did not even start, according to us, because one of the affidavits which were mandatory.
Let come after 2. Yes.
At item number 19, your lordship was supposed to make it dismissed for default. I was in
What
courtroom
can
number.
be done? You were not present.
I was engaged in courtroom number 12, so I could not.
What onion in? Mr. Onion in, come at 2.
Lordship, I'm grateful, madam.
And this is my application. My lord, I'm not facing this application because yesterday I mentioned the matter in the first half. And your lordship's pleasure was to upgrade it. Today is appearing. And yesterday I filed another application for under section 24 for transfer of the suit from Bakuda to Bardhaman. Now this matter was taken up by your lordship. The Honorable Justice Sampadartha Pal, she has allowed my application for transfer. Therefore, it has become redundant.
This has become infructuous.
Lordship.
The learned advocate appearing. Yes, call the next one. This matter.
Petitioner, my lord. Application, my lord. Revision directed against order rejecting my order 6 rule 17, my lord.
Order 6 rule 17 dismissed, rejected.
Rejected.
Who are you?
I'm the plaintiff, my lord. On the ground that it is self-contradictory and it is changing the nature and character of the suit.
Where is the plaint?
My lord. Plain starts at page number 11, my lord.
Where is the amendment application?
My lord, the amendment application is at page number 19, my lord. The relevant portion is at page number 20, my lord.
This application under Article 227.
With my application, my lord, my 7172, my lord, was rejected on the ground that, my lord, it wasn't filed within time despite service of summons. Now, my lord, we have not received the summons. The summons were never issued, my lord, in the tenanted premises. It was issued, my lord, at an address which the plaintiff knew I don't reside there. And because I have shifted. But nevertheless, my lord, at the tenanted
You have shifted.
No, from the suit premises, I'm there. Milord, suit premises is for the commercial office. Milord, I'm there. No service
Summons was served where?
served in some other place, my residence. From my residence.
Where is your 7172 application?
Yes, kindly, Milord, takes my 71, which is, Milord, page 71. And no substituted service ordered, nothing, Milord. On first day, there was no bailiff report, Milord.
Where is the application under section 71?
This is the application, page 71.
71.
Yes. My application under 71 and 72 application is at page 75.
But the court records that you have received the summons on 5th of January 2026.
That is an incorrect recording. There was no record, there was no report of the bailiff, Milord, on that date. Kindly takes the plaint, page 38. The suit property, Milord, is Netaji Subhash Road. This is, Milord, the suit property. Where, Milord, the plaintiff seeks eviction of. And, Milord, my address in the cause title has been shown as 108 Canal Street, Arunachal Apartment, Sribhumi. Now, this address, Milord.
You are not residing there?
Never. We had shifted long back, Milord, and I have pleaded that in my petition. Kindly seize, Milord, a page, para 13, page 4 of my petition. That is my residence, and I shifted to Nirmal Vatika long back. Canal Street, I lived earlier. Irrespective, Milord, at the suit premises, where if, Milord, a notice is served, the Lordship knows in the suit premises, I avoid service, then, Milord, somewhere else they can serve. But without any effort being made to serve me in the property where eviction is sought for, Milord, this is very mischievous. And on the first day, without any report, this order is passed. Milord, order 5, your Lordship knows, Milord, a substituted service could have been ordered. And, Milord, most importantly, Milord, from 2022, when the suit was filed, till 2025, the plaintiff also did not appear. I have annexed those records also, page 47 to 58. Suddenly, Milord, in 25, a summons is sought to be served at a different address, and this order is passed. Impugned order, Milord, page 63. No substituted service. Also, Milord, there is a power of extension also. When summons are generally served, Milord, within. Not submitted. Usually if it's a company, they can under, my lord, your lordship knows order 29, the corporation office must be served. But this, my lord, here I am an individual.
What prompted you to obtain an information slip from the trial court?
Yes, I have said that.
Where?
Kindly see, my lord. Para 9,
Para 9 of
my petition.
civil division application.
Also there, also 7-1.
There. Please show me from there.
Your lordship will, my lord, call for the slip also and, my lord,
No, I'm asking you what prompted you to obtain a
Yes.
information slip.
Para 1 of my 7-1.
Yes.
On 18 March, your petitioner came to know the first.
I'm asking you what prompted you to obtain an information slip on that date. What's the background facts of this? Something must have happened which prompted you to obtain an information slip. What's the background facts? You have suppressed everything.
No, my lord.
What's the fact? Please show me from the application.
Show that. Kindly takes, my lord. Seven one, my lord, 7-2. I have, it contemplates, my lord, that a person makes an application seeking to deposit.
7-1, no application is necessary.
No application. You go and will not pay. 7-2, my lord, you say that this much I admit and this much, my lord, I am disputing, so kindly allow. So, my lord, for that, my lord, we come to court. Now, when I came to court with an application, at that stage, my lord, I have said that I have learned on this date.
What's the background facts? What prompted you? Because you will go and search the court. What was the frequency with which you are searching the court proceedings?
But I bow down. That I have explained in here. No, my
You
lord.
have not explained. You have said on certain such date, I obtained that. It's very easy to say. Yes, after having knowledge, 6 years back, you may have one day go and apply for an information slip and say, yes, today I have gone. So what prompted you? You will not go and obtain information slips on regular intervals.
Very well. May I answer that, my lord? On that day, my lord, I have obtained information slip, assuming, my lord, I have not explained in my 7-2. I came in the revision, I am explaining. But, my lord, kindly...
What you have explained now, let me come to the revision.
I have said.
What you have said? Please show me that.
But kindly see paragraph 7, 8 and 9. No eviction notice. Now, assuming what your lordship is saying correct, my lord, on that day before the court, that on that ground, my lord, my applications were not rejected. That you are not explaining properly. That is why I will not extend. Kindly, my lord, see 7-2, there is a power of extension. I have power, my lord, yes, 7-2.
Extension is a subsequent. After
yes.
the adjudication.
After that.
Not pre. Not at the time of filing of the application.
Yes, but I bow down. But when that, my lord, provision of extension is incorporated in the 7-2 and it comes for the first time, it is the duty of the court, my lord, to see whether the summons has been served or not. The explanation of, my lord, why I came at a delayed stage.
Which court?
And my lord, page 63, at the last order, second.
23rd of March.
23rd March 2026.
What is the next date?
The next date was on the 4th and
This today.
No, 4th happened. Well, what happened, I am not aware. But what I'll show the last order.
Today is the date.
Today is the date. And then last day plaintiff also kindly gives me 2 minutes. Plaintiff from 2022 to 2025 has not appeared also. There are orders I have annexed. Kindly takes page 47 to 50.
Yes. This matter was mentioned.
Appear on behalf of the petition.
Lord, I am appearing on behalf of the opposite party landlord.
Yes.
Plaintiff.
Lord, Lordship, kindly come to my lord page 62. My lord, keeping in the mind of ensuing puja vacation, my lord, I have deposited, my lord, the rent of 2 months.
Lord, I am not delving into the things, Lord.
No, ensuing, I could not follow. Ensuing.
My lord, the page 62, my lord, I have deposited.
Puja vacation, what
My
have you
lord,
done?
at that point of time, 2025, I have deposited
All right,
rate.
please give me a minute. Please give me a minute.
Lord, I have gone through the order passed by your lordship, Lord, and I have found, Lord, that your lordship has made the observation that there is a prima facie case that I have said. Lord, I'm I'm not on that point, Lord. What I'm humbly submitting, Lord, that whatever observation is there from your lordship that stands, the only submission which for your lordship is this is a suit for ejectment.
Please give me a minute.
Madam. Page
Yes. This matter was mentioned by the Yes, next. All urgency at the time of mentioning. Thereafter, when the matter is taken up, nobody cares.
So my lord in this side.
Yes, next.
And I for the petitioner. My application under section 10 has been rejected on the ground that in the subsequent suit, BLRO and collector has been added as a party, but in the previous suit, BLRO and collector was not a party. All others are same, even the pleadings are same. Initially, a suit for partition has been filed, partition declaration and injunctions. Now, during pendency of that suit, another suit for one.
Where is the plaint of two suits? Where is the plaint of the earlier suit?
First suit is at page 14.
1-4.
1-4.
Party same.
Party same.
Suit property same.
Suit property same. Cause of action same. Everything same. Even the pleadings are also same.
The learned advocate appearing.
It's my application where well, I'm the defendant in a commercial suit. My summons was served on me, but when the summons did not accompany the affidavits which are to be mandatorily accompanied with the plaint. Well, that is why well, the time to file the written statement, which is the mandatory under within 120 days, that did not start. Well, despite that, well, I prepared the written statement and file an application for acceptance of the written statement on the ground that there have the summons has not been properly served on me, and that the written statement should be accepted. The court proceeds on the basis that the time to file written statement cannot be extended under the Commercial Courts Act. And that is the sole ground on which my application was dismissed, without any discussion as to whether the summons was properly served on me or not. But
After going through everything, you have accepted. The learned advocates who are engaged, they are falling ill
Yes,
or suffering from accident.
yes, there
After
were-
that, you have accepted.
But acceptance, we prepared the written statement on the basis of the averments made in the plaint.
Sir, this was on a lighter note, sir. Don't take it
Sorry.
seriously.
So sorry. Improper service of writ of summons, my time to file written statement
But
doesn't start.
if according to you, the entire copy of the plaint was not served, was it not incumbent upon you to apprise the court that, look here, the copy of the plaint has not been served? That was not your case when on the particular date you appeared and paid for time to file written
Yes,
statement.
my
Then
previous learned advocate appeared.
how that can be proved? It's only your after it has become time barred, you are coming with a plea that the entire plaint has not been served.
But I have made averments that these are the documents and the affidavits which are
Because
not
at
served.
the first point of time when you paid, it was what you have pointed out. So if you have not pointed out, can you now take a plea after the expiry of the period? So how that will be proved?
But I'll not.
You are saying, they are saying no, I have served.
But I have annexed the summons with the civil revision.
But he knows which pages you have left.
They did not dispute that. They have used a written objection to my application. I have made this averment that I was not served with the statement of truth.
Have they accepted?
They have not denied. They have never denied. And the court does not get into.
Where is your statement with regard to that you have not served?
It is recorded, Malad, in the order itself. Malad, I'll show you.
Your application, please show me that.
Yes.
And their objection.
My lord. Malad, the application, Malad, kindly takes page 88.
Page 88.
Yes. But kindly takes paragraph 9. Page 92, paragraph 9.
Where is their reply to this?
The written objection starts from page 268. Kindly takes paragraph 7.4 where they have dealt with this this allegation. Page 272.
Two
272, paragraph 7.4. It is the same 264. Lordship may also consider it is the same paragraphs which have been dealt.
Summons accompanied by the plan, all annexures were duly served. So they have denied. You have said that they have not denied.
It does not appear from the summons itself.
That's neither here nor there. You have stated something on oath. They have denied that. And you have not taken that point at the first opportunity. After the expiry of time, now you are coming up with that.
I cannot blame the learned advocate who appeared. Malad, I will not do that. But Malad, the previous advocate appeared, and Malad, later on it transpired that the entire copy of the plaint has not been served on me. And these are mandatory requirements under the commercial.
Now, when it was not served, when you applied for time, it
Yes, I
supposes
said
that,
that these
you ought to
documents
have checked up that.
Yes,
the
that is
first
true.
opportunity. Now, who will believe you? After the expiry of the time, after the time has lapsed, you are coming. Look, the entire copy of the plaint was not served.
Malad, if the summons could be perused by the court to see whether these documents were accompanied with the plaint or not, that would have sufficed.
It's difficult now.
That the summons could have been perused, it could have been ascertained.
Now, after the repeated pronouncement, it cannot be extended.
But
What
if the
can be done?
time doesn't start, but I'm not seeking for extension.
Time doesn't start if that finding is there.
But that
How can that be decided? By what way?
The court has not even dealt with this issue.
Merely your allegation. They are denied that on oath. You have stated on oath. They have denied on oath. Then what can be done?
But if the suit records would have shown that these
Sir,
documents
how
were
can
not.
that be proved from the suit records? Even if I call the records,
But
can it be proved that you have not got the entire copy?
I appreciate, but
Then-
not insofar as the summons, I have annexed the summons. I have annexed entire summons which I have received, and the defendant does not say, and the plaintiff does not say that I have not annexed such and such things.
No. It's not a question. They have denied. They are saying that I have sent everything. Then
But the plaintiff does not say that
how many pages you don't have?
My lord, I do not have the statement of truth, which is a mandatory requirement. The lordship will not see that from a copy of the summons. I have not received the affidavits which are mandatorily to be filed under Order 11 of the amended the Code of Civil Procedure. I have not received the board resolution. These are mandatory requirements.
For the commercial court,
So, my lord, I'll indicate. My lord, order me record. Namta bolun.
someone from here.
Written objection. But I do not this this does not have the advocate's
Who is appearing before the commercial court from your side?
from my side, Mr. Shabudi sir.
You will know who is appearing.
Doesn't know the name. Doesn't know the name.
You know, by the order impugned. Call the next matter.
My lord, a ping pong short password. Learned advocate is code Tanmay Mukherjee's code
What is
number.
this matter? What is this matter? Who is appearing? What do you want?
Number? Advocate Tanmay Mukherjee.
Look at the brief. Why are you looking at the door?
Tanmay Mukherjee probably.
He is a busy counsel. Yes, yes, please start. He will not be able to come. Yes, what is this matter? What order you are challenging?
I have no beef, my lord, actually.
Please take my brief. Yes. Didn't. Yes. 3 p.m. I will not allow Mr. Mukherjee to move. Yes. Yes, call the next matter. Yes, next. Don't give that. Oh, you have the brief, all right. Yes, Mr. Basu.
I am for the plaintiff opposite match.
You are for the petitioner.
On behalf of the petitioner, my lord.
Yes, Mr. Banerjee.
This order
Sure.
7 allowed.
Yes.
7 rule 11 allowed.
Yes, section 6. Not 6. Whatever, maybe. So, order 7 11 allowed.
Section
Section 6 final order is not applicable.
Right.
Yes.
It was adjudicated.
Hence.
If that is so, Mr. Basu, the logic is if the yes, good, bad, indifferent, if it is falls within the expression degree. Now here,
Dim degree, not degree. There's a distinction.
no, now it's not dim degree.
It's a regular degree. It's in the definition.
Dim degree is FMA. Now we are saying it includes, it's a regular degree.
Yes.
So first appeal will lie, or regular title appeal will lie, whatever the case is. Now that is
section 6 ছিল না 34 35 or specific relief act ছিল damages it's not simply section 6.
But only thing, Mr. Basu, which is troubling me is if the final order under section 6 is not applicable,
Right.
whether rejection of that can be,
does not adjudicate.
but
Rejection of not the dismissal of the suit.
but
That by law note the distinction between them.
but the question is here, why in those in order 7 to 11 it's decree, from which an appeal lies. That's the logic. You have to prefer an appeal. In ordinary order 7 rule 11. But here in a case of section 6, the final order is not appealable. The final order is not appealable. It's revisable. So why not rejection of that plaint? So interrogatory, Mr. Because what we were taught in a roundabout way that if the final order is not
Appealable. So another thing I can say, whether this suit is a section 6 suit simplicity, because the other players are also the 34, 35.
That's a different. That's a different thing altogether.
Cross the hurdle first, then this question may come up.
Yes. So are you so serious in this maintainability? Because section 6.
I want to argue.
Because
do you have any authority in your support? Mr.
Yes.
Basu?
Two authorities, Delhi and Calcutta.
In section 6 suit.
Because there are consequential reliefs to section 6. It's not only section 6.
Second limb. This is the second limb.
It's not only section
whether
6.
on the plain reading of the plain, it appears that is not a section 6 suit simplicity.
Separate claim for money damages. Separate claim for not consequential. Not consequential.
That's the point. The second limb. First, if it is on the face of it, and my lord's logic is also, I cannot ignore that logic, that yes, when the main matter is not available, they are even then, I say this is rejection of.
Because if it is not appealable, it cannot be said to be a decree. If it is not a decree, if the main adjudication is not a decree, then the rejection cannot be a decree.
It said in specifically this order 7 rule 11 in section 2. Specifically says.
But in a case, adjudication of a suit, it's a decree. But here, section 6 is not a decree.
No.
So, because in the statute itself, there is no remedy of appeal.
Yes.
Or there's a bar to a remedy of appeal.
Yes.
Right.
In either way. So, if that is so, then the question would be whether rejection of a plaint in a section 6 suit can be said to be a decree under 2.2.
The meaning of 2.2.
Yes, when the ultimate decree is not when the ultimate decision or an adjudication is not a decree.
Beside that point, let us come back.
No, let him urge it right now. He's urging it right now.
So, Basu, this shows that you do not have a very good case on merit.
Yes, not at all.
I have a 100% case. I'm not worried about that.
This shows that you do not have a very good case. Those will be academic, Mr. Basu. Are you so serious in this? Because
But Mr. Basu's junior, it's his birthday today. He's prompting his senior, my lord. Birthday boy should not be doing things like this.
he has not treated you, Mr. Banerjee.
I will.
This is the treat he's giving me, my lord. He's giving me additional headache. That's the treat.
আর খাওয়া পাওয়া ফেটে যাবে
প্রেসিডেন্ট পেলেন না Do you have a copy of the? Do you have any judgment in your support?
Yes.
Section 6.
6 along with other press.
I said the second link. First, not only section 6, but the plaintiff looked into it will couched in the fashion. It is also 34, 35.
Nomenclature দিয়েছে ইনভার্টারি হেডিং ও তাই দেওয়া আছে 34 35 হ্যাঁ হেডিং এ দেওয়া আছে একদম 34 35 দেওয়া আছে হেডিং স্যুটটা ফাইল করেছে নমেনক্লেচার দেওয়া আছে 34 35 আই টু আগে
এই এত মোটা দেখতে ভালো লাগে
so it's a combination
So I can decide this right now. Your maintainability point. I've got my answers for that section.
You're not Khada.
No. From section 6.
No. If it is section 6, then I can concede to that extent. I will not argue that.
All right. So you are on the
second link.
I have said
please show me the plaint.
Yes, come to the
page 30.
Page 30. খুলি তাহলে খুলতেই হবে
We'll be starting next. Adjudication তো করতেই হলো 38, 39.
Page 40.
41 এ damages ছিল।
Proceeding, my lord, can I decide? It is a section simpliciter suit.
হ্যাঁ, sorry.
Rule 11 allowed on what ground?
No cause of action and barred by law, both.
Two grounds, no cause of action, barred by law.
Oh, that will come
Barred
later.
by law is patently not applicable.
Barred by law is on what ground?
KMC Act 1980 has a procedure for demolition. Therefore, civil court could not grant a decree of mandatory injunction directing demolition.
That will
Which
come
is,
later.
with respect, is legally perverse. The only ouster clause.
Mr. Banerjee, only one thing is the suit.
দিল্লিতে খুব ভালো একটু
Really a suit under section 6?
I mean,
Or,
a mixed suit. Yes, yes. Whether other reliefs
so
are
if
there.
the other reliefs are there, then the question is whether Order 7 Rule 11 would come within the definition of decree and appellable. Because if the final relief is granted either way or dismissed in either way, so it would be a decree appellable under section 96. If that is so, whether Order 7 Rule 11 in such a suit will
Couched in a good manner, but
The question is whether, my lord, if it is a mixture of reliefs that has been sought, one of them is under section 6, then whether that part of the order which decides the section 6 can be said to be a decree, and whether this surgery will be possible. That's the only question.
No, Mr. Banerjee, the suit as a whole, the plaintiff has been rejected. Plaintiff do not speak only of section 6.
Yes,
So
plaintiff is
it's-
yes. Multiple, it's composite.
Bar under section 6(3) applies
Only to the section 6 relief.
Yes.
Only to the section 6 relief,
Yes,
not
the
to the other reliefs.
scope is very limited under section 6.
Yes.
But
Possession
here
6 months, possession 6 months,
Yes.
and dispossession.
Yes.
Limited to that extent, below the bar under 6(3) applies, and I am protected because that's one of my prayers. As a
No, but
plaintiff, I
here-
have the right. As a plaintiff, I have the right at any stage of the suit, if necessary, to abandon a few claims to make the suit maintainable.
No,
That
is
I
it
can do,
your-
my lord.
no, Mr. Banerjee, then you have to say that you are abandoning everything.
No, I will be arguing, my lord, in my
No,
reciprocal
then,
submission.
Mr. Banerjee, so then, unless and until you abandon, we have to consider the plaint as it is.
As it is, yes, yes, definitely.
So if
definitely.
it is as it is, so you cannot say it's a simpliciter suit under section 6.
Yes, in that case,
Consider
my lord,
this.
yes, I'll consider this. I can come back straight away, my lord. My humble response will be that insofar as the relief in connection with section 6 is concerned, even if the suit has composite relief sought, the relief, the final outcome qua the section 6 relief
No,
does not
Mr.
amount to a decree.
Mr. Banerjee, there, I can add a rider to that. Let us assume a suit is filed claiming multiple reliefs. Now, some of the reliefs is barred by any law.
My lord.
Plaint cannot be rejected.
Yes, in part, yes.
So if that is so, so while rejecting, it's a whole. Whole means entirety, not restricted to section 6.
No, my lord is looking at the remedy. My lord is looking at the remedy.
Yes,
remedy
remedy.
Remedy for me would be appeal qua the other parts and 227 for this.
No, no,
That
no,
is the
no, no.
question. That is
No,
the question. This I will
that-
I'll consider and come back. I'll give you lordship, lord. I believe that this is
It
covered.
cannot be piecemeal, Mr. Banerjee. It cannot be piecemeal.
Relief also cannot be piecemeal. So
Yes.
do I therefore get to file an appeal in respect of a section 6 kind of relief just because it has been compositely clubbed with other reliefs which are in other provisions of the Specific Relief Act? That is the question. The question to that will be, I am entitled to a comprehensive proceeding. This
3 and then
comprehensive
60.
proceeding here would not be a bar qua the Section 6 rejection. I am one with your lordship that the rejection cannot be part. Rejection has been of the whole. I am looking at it from the point of view of remedy available. My remedy available under Article 227 or Section 115, as the case may be, does not go because of the fact that my Section 6 prayer is very much germane. It is a suit under Section 6 and other reliefs. So therefore, my lord, the question of bifurcation of remedy surely will not come. It's not as if regarding that part of rejection where other reliefs are there, I have to file an appeal. And that part of rejection where the Section 6 relief is there, I have to come 227. So 227 in my response submission would be maintainable. I can, my lord, bring authorities on that in case of relief, there can be no question of bifurcation.
Yes, then if there is no question of bifurcation, then whether in a case whether from part appeal lie, part appeal does not lie. So whether 227 can lie against the entirety.
But if
or
227,
still it cannot be
yes,
done.
227, my lord, fundamentally 227 would lie against the entirety because 227 is a constitutional power which is higher than 115. It is not that there is any bar. It's not that there is any bar. There is, of course, a very
Mr.
strong
Banerjee,
self-imposed restraint.
Mr. Banerjee, Supreme Court judgments are against you.
No, I know. I will come up with them and I'll show you.
Supreme Court judgments are against you on this.
I'll show you, lordship, lord, from there. That
Because 227 in a civil proceedings,
it will be akin to 115. Will be akin to
no,
115.
even if 115 will not be maintainable.
So
Even if
115.
So
no, 115 regarding Section 6 would be maintainable.
No, that is purely simpliciter Section 6.
Simpliciter section.
But
No,
if some other reliefs are clubbed, you cannot
then whether
only Mr. Banerjee, the scope of Section 6 is a summary proceedings.
yes, only to get you back to possession.
Yes.
If you are in possession within 6 months, get you back to possession on your possessory title, nothing else.
That is why the logic of restricting the right of appeal is only for that. Only you prove your prior possession
and you come back.
Yes.
And if you have to file anything on Section 5, that is
Yes,
then you take a separate suit.
Speedy remedy for that. That is why the remedy of appeal is barred.
Yes, my lord, I think the fundamental question is whether this remedy would be available to me under 227 today. This I can answer up. Your lordship keeps it for instance, tomorrow I can come and answer up. I'm sure that I'll have an arguable case to present. Thus, Mr. Sarkar would have expended his birthday. He would be less hostile towards me tomorrow, I guess. Tomorrow? Because I am in need of interim relief, I tell you, lordship. I can't seek it now, but I am in need of interim relief. I was enjoying an injunction. Which was extended for at least 5 occasions, which has not got vacated.
Same proposition.
Yeah, fair enough. If the citations can be given, I'll have a look at it.
We have given it to your learned advocate.
Yeah.
Good night.
Consider these judgments, Mr. Banerjee. Though one of the judgments may not be a binding precedent, may have a persuasive value, but it more or less matches with the reasoning. Yes.
I'll surely consider and come back. Lord, tomorrow, if your lordship kindly keeps it. I am in need of interim relief subject to maintainability.
This application.
Malavidu lordship's officers could kindly put me back again. Yes.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff challenging an order passed under section
Order 7 Rule
Order
11.
7 Rule 11 of the Code of Civil Procedure, challenging an order allowing an application under Order 7 Rule 11 of the Code of Civil Procedure. First up, Mr. Basul, an senior advocate appearing for the petitioner, for the opposite party, raises an objection as to the maintainability of this civil revision application.
Cannot say maintenance. Entertainability. 227 always maintenance. Entertainability.
But in a civil proceedings, it's also not maintainable.
এখানে
It
সব
has
dead
been said,
maintained.
total bar.
Total bar.
Supreme Court has said.
Court can say the constitutional remedy is barred.
Because there is a distinction.
Entertainability may be barred.
In a way, entertainability,
Yes.
but distinction has been made between two classes of two proceedings. One is 226, 227, Mr. Basu cannot be a bar.
That I'm saying.
So even if there is,
That.
even if the distinction which has been made, even if there is an alternative remedy under any statute,
That is one thing.
so even if there is that, you can invoke. You can invoke. That is, you are saying entertain. Yes, maintainable, always maintainable, but entertainability, whether entertainable, but in a civil proceedings, the Honorable Supreme Court has made this distinction. In a civil proceedings, that cannot be invoked because in the civil procedure code there is a specific remedy available, and that I've referred to in another judgment as near total bar. That's the exact expression used.
Yeah. But thankfully, the word near is there, my lord. Thankfully, the word near is there.
The expression is the cost title is the second party is Tuticorin Educational Society, delivered by Justice Noriman. 2019, I think 9 or 7. 9 or 7. Yes,
Let me check up.
2019.
Can Supreme Court say constitutional power is barred?
near total bar.
That, my lord,
Because this is the distinction made out, and it has been example has been given. Otherwise, against a decree, you may say it's without jurisdiction.
Because in the Allahabad decree against the decree, there is an appeal.
No, Supreme Court says no, you cannot do that. In a civil proceedings, you cannot do that.
But I have the instance. I asked this question to Mr. Mukherjee.
Supreme
I cannot
Court
say what he has answered to me, but ultimately I found in Allahabad judgment 227 against the decree.
Supreme Court has now said you cannot do.
No, not entertainability. If in a given case, a decree is manifestly on the face of it.
That is why use the expression cannot
Nearly.
near total bar.
Near total
Cannot
bar. That is why I'm telling you. So near total bar, because cannot be said to be an absolute. So
cannot be said. That's why my.
So that window is let, but it's a very small window. You cannot pass through that window. It's difficult to pass through that window.
Even I can show to your lordship in your lordship's court is so far mere bar has been entertained and entered in a case order 13 1 and 2.
Mr. Basu, I've got that was cited before me also. I've come across. I'm in the process of deciding in one matter because
absolute bar.
In that matter, I have told that this is the judgment of the Supreme Court. So
window is there, can be entertained.
Because that example has been given. Otherwise, someone will come against a decree in 227. That's the example has also been given.
Don't entertain.
That's up to the court whether
that's what I'm saying. I'm not saying advising the court. Not entertainability. It cannot be entertained, but you cannot move it. It is barred. Subject to correction cannot say. Constitutional power.
Otherwise, Mr. Basu, it will be a dangerous proposition. If you allow that, it's a dangerous thing.
Floodgate.
Floodgate.
What is doing?
27.
Supreme Court is doing.
27, Mr. Basu. Yes, entertainment is one thing, but scope, how far you can go, those limitations will come. That cannot be akin to a first appeal in 96.
Not.
Then.
Certainly not.
Then.
Entertainability depends upon court.
What's the use, Mr.
That's
Basu?
what I asked.
You are curtailing the scope.
I am submitting, don't take me otherwise. I am submitting that the court cannot say, the constitutional court.
Oh, as to the entertainability of this civil division application as an order allowing an application under Order 7, Rule 11 of the Code of Civil Procedure falls within the expression decree under Section 2 within bracket 2 of the Code of Civil Procedure. So he further submits that the suit in the case on hand cannot be said to be a suit under Section 6 of the Specific Relief Act. And in support of such contention, he draws the attention of the court to the averments made in the plaint and the reliefs claim therein. First up, first with such submission, Mr. Banerjee Lanet, senior advocate, prays for an accommodation to revert back with necessary to revert back to assist the court on the next date. Yes, when do you want to come back?
Tomorrow, my lord, tomorrow. I can come back and assist your lordship too.
Any other day, my lord, this no interim order can be passed. Subject to my lord's diary. What tomorrow?
When do you want? Please suggest a date.
Tomorrow, day after, whenever it's convenient.
After? When do you want?
Day after.
Once.
Eh?
Day after tomorrow.
Day after. Obligation.
Yes, next.
Item number
4.
Eta specifically fact onion even. Yes.
My lord, item 13. My lord,
Yes.
Item 13, my lord, I am led by Mr. Devjit Mukherjee, my lord. This matter is, my lord, for expeditious disposal of the
This
titles.
application under you are the plaintiff.
My lord, I am the plaintiff.
What is the stage of the suit?
My lord, examination is going on. Evidence is going on, my lord.
Evidence going on.
First examination is going on, my lord. Next date is fixed on 19th of August 2020.
19th of August.
19th of August.
This application under
Objective for the petition. Expeditious disposal suit of 2005.
what is the stage of the suit?
Evidence has been completed. Thereafter, mediation failed.
Evidence completed?
Yes.
When evidence completed?
24. Paragraph 4. DW witness was closed on 2/9/2024.
2/9/2024.
Evidence completed. Thereafter, mediation failed. That is in the year 2025. Thereafter, administrative transfer. Now, defendant number 1 died. Substitution application pending. Last date was fixed as per information on the 8th of July.
The Order 22 Rule 4 application, what happened to that? Substitution done?
No.
What is the next date fixed for hearing of the substitution application?
8/7. It was 8/7, 8th of July 2020.
What happened on that date? This application under Article 227 of the Constitution. Yes.
So I purchased a particular land and leased a building. Sold 8 tenants. Now some of the portion of the land was used by
You are the plaintiff.
Twice my injunction has been refused in last in this appeal. Challenging the order passed by the learned district judge in this appeal, I am challenging. Actually, my injunction application has been refused. Simple. Now, a particular portion of the land which was not transferred is being used by me, by the plaintiff, as his garage. Now, some of the flat owners, not all, some of the flat owners have put a gate and prevented from using that particular land. This is the fact. It is simple. And my application for injunction.
Where is the order passed by the trial court?
Well, the trial court order, my lord, I have not annexed. I have annexed the order of the.
You have to annex the trial court's order also. Where is the trial court's order?
Trial court order taken. I can bring the order tomorrow, my lord, if your lordship so desires. I can move it now also, but for your lordship satisfaction.
Yes, call the next matter. 42, yes, Mr. Mukherjee.
Order 3907 has been rejected.
Rejected?
Well, my father suffered a DD. No appeal was required.
What is the suit for?
For eviction. My father suffered a DD.
Suit for eviction? Local inspection for what?
Well, I'm done. Well, my father.
This is Biscus 47.
What happened? Why? Well, if you lordship, well, they say that 2 rooms. In fact, 1 room, and outside the room, which is not beyond the suit property, I run a tea stall. Well, it's what I want. You take away position, all right, but my position where I am running a tea stall, that is beyond the suit property. So if it is, my lord, taken up by your lordship, at least at time of 47, to take up,
let me see,
so that I can survive. So that has not been discussed. I have stated in paragraph 9 that in fact the petitioner runs a tea stall in the suit property for survival, and there is left some land also beyond the suit property under possession and control of the petitioner, where he could continue his said tea stall for his survival. Because we are not advised to pay for any appeal, unfortunately. And
where is the decree? Where is the decree?
Well, decree I have got the copy. I have not given. Well, here is the decree. If your lordship, I am giving by hand. Then it is described as 2 rooms.
2 rooms, yes.
I am living in 1 room. If your lordship direct the commissioner to ascertain how many rooms, the lordship will find 1 room.
So you are in 1 room, vacate 1 room.
No, yes, but beyond the suit property, if it is commonly measured, a land is, my lord, there where I am running a tea stall, which is beyond the suit property. Unless it is measured, my lord, I cannot establish, because I had no problem. My lord, if your lordship once, my lord, turn to page 16, the application, who filed this application? Application was filed by my father when he was 100 years old. Page 17. You see, I see Subal Sanju Saha, son of late Hitalal Saha, aged about 100 years. He was so active. And so I had only this application in hand to establish my case.
And commissioner can report in how many rooms I am dwelling. And it is measured, my lord, that where I am running tea stall, it is beyond the suit property. This much facility, unless I am not given, my lord, practically it is for his survival as a running tea stall. Court has given general view, as your lordship wanted to point out.
Yes, so this point you took in the suit, you could not succeed.
I bow
Now,
down to
Mr.
your
Mukherjee,
lordship. Your lordship,
in the
I bow down to your lordship.
this application. Yes.
Pilot, I'm the
Yes.
I'm a married daughter, and opposite party is my brother. There is an undivided property.
What do you want?
Expeditious disposal. That's it.
Of
The suit. Number 620 of 2022, pending before senior judge.
what is the stage of the suit?
stage of the suit, Lordship, 14 times it has been adjourned for different reasons. And now it was fixed for the last date. It was on 19th June 2026.
This application under Article 227 of the
It's my application. Milord, I am, Milord, the defendant number 1 in a suit. Milord, what has happened is, Milord, I adopted a girl child when the child was 1 year old. Adoption deed signed, executed. Milord,
What is the impugned order?
Milord, may I just indicate? 7 years later, Milord, the biological mother has come back from nowhere, filed a suit, and obtained an order that I should be making her meet my child last Friday of every month, and she's free to talk to the child and give the child chocolates, etc. The child, Milord, is 8 years old. I am the only mother, Milord, that she knows. She's not aware that she's adopted, and this is not the right age for it to be disclosed to her that she's adopted, because, Milord, she'll be, Milord, jeopardized for life. And, my lord, the learned trial judge doesn't, my lord, address the aspect of the welfare of the child, which is, my lord, the primary, my lord, aspect to be looked into, my lord, in these kind of matters.
How this adoption was made?
This adoption, my lord, was made, my lord, by execution of an adoption deed.
Where is the adoption deed?
Yes, that has been challenged in the suit. And, my lord, the lady says that she has signed it, but she's saying that she wasn't aware what she was signing. She was made to sign without the usual story.
So now if that is under challenge,
yes.
So can you deny this right of visitation?
My lord,
if the adoption goes, so can you deny the biological mother the right to meet the child?
Yes, my lord, that's the question. Now, my lord, may I answer this? My lord, there are two aspects here. Firstly, my lord, this is beyond the scope of the suit. Suit says not to give effect to the adoption deed. Second prayer, first prayer, declaration. Second prayer, permanent injunction, not to give effect. The question of, my lord, getting the child or getting, my lord, custody.
Not getting the child for the
visiting.
Present, yes, visitation.
My lord, it's under,
under
151. Under section 151, inherent powers, my lord, the civil court, my lord, has passed this order. My lord, this squarely comes under, my lord, the 1890 Act, the Guardianship and Wards Act, where, my lord, an application is required to be made. It's a special form of an application. It has to be, my lord, signed in the presence of 2 witnesses.
Those are technicalities. Those are technicalities.
Then it boils down to equity, and it boils down to this: that today the child is 8 years old, and the only mother whom she knows is me. Whether it will be in the welfare of the child for the child to be disclosed by somebody whom the child has never seen, who was not around for 7 years, pops up after 7 years, challenging that though it's her sign, but she didn't read the papers properly, and that now she's in circumstances.
Please give me a minute. Please let me go through.
My lord, I am not disputing that this is the biological mother. And the trial court on that, just on that point, that admittedly she's the biological mother, goes to, my lord, pass this order. My lord, the trial court hasn't considered whether this is, my lord, to the benefit of the child or the welfare of the child at this stage.
Now, please consider, if ultimately the adoption deed is set aside, what will happen?
My lord, if the adoption deed is set aside.
After 6 years?
After 6 years.
So then if, the child will not be knowing that biological mother. What will happen?
My lord, then in that event, the
She
adoption
will
would-
take advantage of that
No, my
position.
lord, adoption, my lord, will be rendered void.
So now the she will not know a person. She will go to a person whom she does not know.
Lord, may I point out one more thing?
It's better the earlier in point of time she meets the mother.
My lord, this may not perhaps
That's
be
the welfare of the
your
child.
lordship will, my lord, consider this, my lord, may not be, my lord, the right stage. Second aspect, the learned
What
child,
would be the right stage according to you?
perhaps when she is about 13 or 14, a little more mature. That because, my lord, in these adoption centers, my lord, when they give a child for adoption, my lord, it is always, my lord, advised that you must disclose to the child that the child is adopted. Never conceal this forever. But the right age, my lord, is, my lord, when the child has attained some level of maturity to be able to, my lord, understand, my lord, the gravity of the situation. Not when she's 8 years old. Not, my lord, when she's of an extremely tender age. And, my lord, may I go a level ahead? My lord, may I go a level ahead and, my lord, frankly confess, even the adoption deed, my lord, although they've challenged the deed, I don't think, my lord, the deed holds much water. Because the couple, the lady who's adopted, is a Christian. Christians cannot adopt today by way of a deed. It has to be, my lord, under the Juvenile Justice Act. And, my lord, my lord, division bench previously has taken cognizance of this aspect. That yes, the only string on which this entire suit rests is equity, on which the parties will have to fight it out. Because, my lord, under the Juvenile Justice Act, one doesn't have a choice of, my lord, adopting a child. You have to make an application and wait. And then, my lord, you have to adopt, my lord, the child which is being given. For Hindus, my lord, there is of course a law. There can be adoption by, my lord, numerous ways. But for a Christian, there's no, my lord, adoption law specifically in our country. So it has to be under the Juvenile Justice Act. Therefore, this deed doesn't hold much water. The only string, my lord.
That's the basis of which you are claiming your right.
Exactly.
My lord goes. Please return the child. Please return the child then.
You
are challenging the very basis by which you have got the child.
My lord, may I just
So
point?
what are you submitting?
My lord, may I just point out?
I gave you time to make that submission.
No, my lord, may I can't.
So if you
My lord,
say
there's a finding
the
of
very
a-
basis you want to destroy that, please hand over the child. I record your submission that by virtue of which it could not have been granted. End of the matter. Please hand over the child.
My lord, this is another legal. I'm saying, my lord, this is another legal
Please
aspect.
think about the matter after before making argument.
May I just indicate?
So one time I can give you time. Please get yourself ready. If you make this type of
No, my lord,
submissions, it's difficult.
My lord, I am
Your
pointing out.
lordship, there is ample malafide intention. I'll show your
My
lordship.
lord, may I just, my lord, indicate, my lord, these things that I'm submitting, my lord, these are, my lord, observations, my lord, before an honorable division bench.
I accept your submission. Then it goes. Very basis, it goes, you take through the regular process.
This is an argument that they will make. So before they make this argument, my lord, I'm giving my answer to this argument that even hypothetically assuming if this argument succeeds, my lord, even then, my lord, the division bench has held that even if this argument succeeds, because, my lord, there was first, my lord, an interim injunction application under Order 39, Rule 1 and 2. There they did not get this order.
What the division bench has held?
The division bench held, my lord, that if I am to take the child outside West Bengal, I will intimate the trial judge and or seek the trial judge's approval if I'm taking the child outside West Bengal.
By this order?
Sorry?
By this order?
No, my lord. May I just indicate one of the facts? Firstly, they filed a suit. In that suit, they filed a 39, 1 and 2. Prior to the suit, they filed a writ. The writ court didn't entertain, saying, no, the child is healthy, so this is the custody matter, you take it before a competent forum. They took that in appeal before, my lord, mandamus appeal. That also, my lord, was dismissed. Then they filed a suit. In the suit, my lord, they wanted an order, ad interim order, my lord, to restrain the child's movements, etc. So the ad interim order was refused. My lord, they went up in appeal. In that appeal, my lord, the division bench, my lord, made some observations and held that equity is perhaps what is the crux of this suit. Whether in equity this child should remain with the parents or not, whether adoption in equity will sail through. And keeping that in mind, it gave a restricted order that you take your child wherever in West Bengal. If you leave the boundary of the state, then you will be you'll have to take the trials court permission. And it directed the trial court to consider this permission within 7 days. Whenever I have to take the child, within 7 days, the trial court will decide. Now, my lord, and the matter was remanded back for adjudication of the order 39 rule 1 and 2, my lord, finally. That adjudication has been done. In that adjudication, my lord, the learned trial court has passed an order that the child will continue to be with me if the child has to travel. If I am to take the child out abroad for more than 90 days, in that event, I will have to take permission. Otherwise, if I'm traveling for a period less than 90 days, I need not take any permission. On every date of the hearing before the trial court, I will only keep the court intimated about the child's location. That is all. But 90 days at a stretch, if I'm taking the child away to some other country, I have to take prior permission. This is one of the only restriction that was placed. And my lord, the suit, my lord, was to... Now, after this 39, 1 and 2, my lord, they move another application under section 151. And in that, my lord, they have, my lord, gotten an order that the last Friday of every month, I will take the child to the legal aid service office, the district legal aid service office. And in that office, the child will be there and the biological mother will come and the biological mother will meet and interact with the child and will also be at liberty to give her any gifts or chocolates or those kind of things on the last Friday of every month. Now, my lord, this is the order, my lord, which really, my lord, brings my motherhood into jeopardy. Because, my lord, the child has been with me since the child was one.
Show me the adoption deed.
Yes, my lord, kindly consider. The deed of adoption, my lord, is at page 39. Evidence Act. Old Evidence Act. My lord, your lordship is there? My lord, the deed is of 8th.
Please give me a minute.
Yes, my lord. Every page is signed. my lord.
defendant number 2.
Where is the plaint?
Yes, your lordship will, my lord, consider. The plaint is at page 147.
Your Lordship, before your Lordships move on to the plaint, may I only point out that is not the deed of adoption. That is not the deed of adoption which my learned friend referred to. The deed of adoption is at page 46.
Where is the deed of adoption? What did I show them? What did I show? What? 39 then? 39 on the adoption. Any difference in these documents? Same date. Same date.
Yes.
This is, my lord, the plaint. So, my lord, there is an agreement of adoption and a deed of adoption contemporaneous of the same date. So, my lord, it starts from pages 39. My lord, the agreement, my lord, ends at page 45 and 46, my lord, of the same, my lord, day, my lord, is the deed of adoption. Now, my lord, the entire, and my lord, it's signed on all pages. It is notarized on all, my lord, the notarial stamp, my lord. There has to be, my lord, an inference of, my lord, genuineness, my lord, if there's a notarized stamp on a document which is signed by the parties on all pages. Evidence Act, beta.
What is the age of the child now?
My lord, she has turned 9.
9 years.
She has turned 9. It will dent her for life, my lord. This question of welfare of the child should have been addressed by the learned trial judge. And then had he come to a finding, my lord, it would have been a just finding. This entire aspect of welfare of the child has been given a go by. I'll show the impugned order. It proceeds on the basis that she's the biological mother. I'm not denying she's...
Cannot deny that.
I'm not denying that, my lord. I am not denying that, but that can't be the only factor. It is not, my lord, axiomatic that if the mother is biological, it inures to the benefit of and the welfare of the child to meet the mother at this stage in her life, whose existence, my lord, she doesn't even know about.
The only question is that the very basis of adoption is under challenge now. Now, what will happen?
My lord, this way.
After, because the suit will take a long time.
My lord, this way.
What will happen if there is a severance of relationship between the biological mother and the child for a long period? It will have a tremendous effect. After the when the suit will ultimately be disposed of. If the suit is decreed, what will happen to the child? Please consider that. You are only thinking of your own.
Yes, my lord, I am that angle.
That's the difficulty. You are not thinking of the child. You are using the expression welfare of the child, but you are not thinking of the welfare of the child. This thing, what will happen if the suit is decreed?
Now, my lord,
after some time, and he or she does not know the mother.
My lord, then, my lord, may I just turn it around a little and place it in a slightly different way? It is a sensitive matter, my lord, no doubt. My lord, if, my lord, just on the basis of, my lord, a deed being challenged, my lord, tomorrow,
Sir,
any person...
Sir, what I can do, I can expedite the suit. That's better. It's difficult because why are you preventing this order of visitation? And it's only fourth Friday of every month, once in a month.
My lord,
and it's also been protected that if it falls within any intervening holidays, then after that, every protection has been given.
No, my lord, I'm not on that. My lord, I'm only on the
and
child.
Expediting the suit.
My lord, I'm only on
I
the
think that's better.
Order of...
So if the suit is disposed of one way or the other, this interim order will go.
My lord,
Great.
What is the stage of the suit?
Your lordship, we can enter the trial stage.
Trial stage?
We can enter the trial stage. It's ready.
Written statement filed.
Written statement filed, issues frame, my lord.
Issues framed. I'm directing the suit to be disposed of within 6 months.
The examination in chief has commenced.
6 months.
My lord,
The examination in chief
I think that's better.
No, my lord, of course, I'm not, my lord, coming in the way of the suit being expedited at all. But, my lord, I just have one, my lord, fear.
Please take instructions, come back. I will be expediting the suit on a day-to-day hearing basis. I will direct the suit to be disposed.
Then in that event,
one way or the other, the child will.
But your lordship, they are in contempt of the learned court since September 2025.
I'm not interfering with the contempt.
Because
pending before
kindly
the
allows me
division.
only 1 minute, your lordship. We had issued a contempt notice in December 2025. It is only after such contempt notice they have suppressed it. It is only after such contempt notice they have taken steps to file this revision because our contempt application is pending.
You proceed with the contempt application.
More than that, your lordship, I have ample evidence to show that they are in moving with the malafide intent to suppress in absolutely that I am the biological mother.
No,
I have evidence.
She's a biological
Please
mother.
take instructions. With this present arrangement, I will direct the suit to be disposed of in 6
Lord,
months.
may I only, my lord, indicate
And,
one thing?
your
My lord, just, my lord, kindly consider, my lord, the other angle also. Then your lordship, my lord, then may
I will
weigh.
consider all angles. After you take complete instructions, then I will dispose it upon merits. One way or the other.
On merits, my lord. My lord, because I'll just
One
indicate
way or the other, I will dispose it
my
of on
friend, my
merits.
lord, can also
But
come to it.
please,
I am
take
ready to argue the case, your lordship,
Lordship, my
because
lord, is your lordship is, my lord, considering passing the order that your lordship was suggesting, because the deed is challenged, and therefore there is a possibility of the suit succeeding. But my lord,
maybe either way.
my lord,
So if
either
the
way.
suit succeeds, so we have to consider both ways.
But my
If
lord,
the
that
suit
way.
succeeds after 7 years and the biological mother and the child is severed for these 7 years, what will happen?
My lord, just two points, my lord, short. My lord, firstly, if this law is laid down, then perhaps, my lord, anyone.
I'm not laying down any law. After hearing you, I will lay down the law. So that is what I'm giving you time to take instructions.
And your
come back.
lordship kindly.
I'm not making anything today. When do you want to come back?
Your lordship, there is
What is the date fixed in the contempt application?
Contempt application, your lordship, it has been
the learned judge
it's
was
running in the list, your lordship.
one of the
It's
last-
running in the list. It
this
has
is
been
the last-
adjourned at the
last
request
order
of my
passed.
learned friend. It is running in the list.
So contempt before this court?
No, before
Yes.
court 8, your lordship.
No, before the honorable division bench, my lord.
your lordship.
This order has been passed, my lord.
Before the honorable division bench.
And your lordship, further with the malafide intent, before this order was passed, I can show that when this matter
No, these
was
words are very easy to throw. Mala, you come after 8 years and you say
and
malafide
yes,
find facts.
I have enough evidence to support my statements.
Give your child
Unlike
away,
yours.
come after 8 years and
Your
then
lordship,
say malafide.
after
And I'm
this
the one who's brought
came
the child
after
up.
this civil revision came up, when the contempt application
studies
was
in one of
not
the
on
best schools
board,
in the city.
they
She's
took
leading the happy
adjournment, your
life.
lordship. The order to
I have given her a very happy life, my lord.
All right.
Let's
come back.
Your lordship, they had
Lord,
taken
next week.
precisely, they had taken adjournment when the contempt proceeding was not on board. And after they took adjournment, for couple of months, they did not
on Friday.
Kindly keeps it on Friday and let it be heard out.
Friday, my lord.
Let it be heard out.
After
May I cut short the matter? This is let me let me cut short the matter. My lord, if my lord passes any order, this will be an order. But my lord, what has happened is on a given day they failed to file their brief note, their evidence on affidavit. Acme, reply to the evidence on affidavit. My lord will
reply to the
questionnaire.
Reply to the questionnaire.
My lord will not go into the merit of appellability or not. Allow that by payment of some cost. That will serve the purpose. Their promoter.
Fault of the either of the petitioner or
He's not conceding. He's not opposing. I can say. He says
Goes
without
one
going into
step
the
back.
Yes.
Because that will not be an order on merits. Because their promoters, I am sufferer. Allows the that affidavit to be taken on record and proceed with the argument, but payment of cost.
On payment of cost.
And otherwise, then I have to go on merits.
So this is what happened. Please give me the facts.
The facts is that I have filed this application under the old act for my flat not been given. These are their
For
promoters.
your flat. So yes, you
Now-
are the complainant.
I'm the complainant. Now what happened was they had filed their evidence. I had filed my questionnaire. On one day they took time. On the next
Before
day,
the district forum or the state commission?
State Commission.
State commission.
Commission.
Yes.
Now
So you have filed your questionnaire. So reply to that. They have not filed within the time.
No, they one day they could not take file. The next day when the filing was there, his advocate was going from one court to other. Junior was appointed. Junior could not take time, so closed. And then they filed a revision.
For recalling of that.
Court said no recalling.
Where is that order?
the period for filing reply.
For where now your reply is ready.
Yes, that is annexed to the petition.
All right. But you have to file that reply before that. By which order, Mr. Laidi, it was closed?
My lord, that order has not been annexed. But
where do I get that reference?
Reference. So first order 17/6/25.
Order was passed by this commission. So 17/6, an order was passed directing them to file reply.
People are questioning.
That's
That's
in a certain time.
Yes.
That they have not done.
No, on that date was closed.
Oh, on that date it was
Because
closed.
their explanation is advocate.
By
was-
which date they were directed to file?
Yes, yes. That I have. That I am not.
On the 17th of June 2025, the matter was fixed for filing my reply.
It was closed the opportunity. As the learned advocate did not appear in time.
Yes.
Uh,
Lordship, on call, when the matter was called, item number 4, I could not appear.
Then you file an application for recalling of that.
Lordship, subsequent.
This application under Article 227. 500. Yes, next.
My lord,
Yeah, what is this?
for the petitioner, my lord. The petitioner number one is currently, we didn't receive any instruction from him. I'll only praying not today.
Not today.
Only not today.
That is one thing you should not pray. Please make other submissions.
My lord,
Except not today, make other prayers.
on the last
Yes.
occasion, it was submitted by them that one of the opposite party has died.
Yes.
The revisional application has been filed against a dead man. Kindly see the last order.
They have not taken any steps.
They have not taken any steps. This is the last order, my lord, 3rd July. Learned advocate appearing for the opposite party number 1 submits that the opposite party number 2 has passed away in the meantime. Learned advocate appearing for the petitioner seeks time to take instructions and to take necessary steps. They will take steps.
Your lordship, the thing is that we don't know that.
Not today. Yes, next.
Grateful, your lordship. For the petition.
Yes, 47, yes.
With this matter, my lord, the executant and the other plaintiffs, my lord, they
File this. Yes.
that matter, my lord, already my lord, this is the copy of the plaint and the application was
Yes, what is this matter?
well, a suit filed by the executant and the other plaintiffs for declaration cancellation of the gift deed, my lord. Gift deed executed by the plaintiff number 1. I am the defendant petitioner, my lord. My lord, in that suit, my lord, the defendant petitioner subsequently filed an application for non-maintainable of the petition and another application where the report filed by the expert opinion regarding the LTI of the plaintiff number 1. My lord, that application rejected by the learned trial court. My lord, on the ground that but the application in the maintainability application, my lord, the 2 points were taken by the petitioner, my lord. One is that stamp duty has not been given by the plaintiffs properly as it is a suit for cancellation.
Where is the plaint?
Yes, my lord, I have handed over the copy of the plaint, my lord.
Who has executed this gift deed?
Well, the plaintiff.
No, this sale deed. Sale deed.
Well, it is a sale deed. Plaintiff number 1. And rest of the plaintiffs, they are the daughters of the plaintiff number 1.
the learned advocate appearing for the
Okay.
48. Doing 48.
My lord, I am for the defendant petitioner.
Yes.
My lord, this is my lord for rejection of the application under 7.1 on the ground of limitation.
What is wrong in this order, Mr. Chakraborty?
My lord, I am showing my lord. My lord, admittedly, my lord, the suit property is a go down. My lord, my lord, kindly see the plaint. Kindly see the plaint, my lord, page 27, paragraph 2. The defendant, until his tenancy was determined by the
On the point of limitation, Mr. Chakraborty.
Yes, my lord. My case is that admittedly, my lord, kindly see the page, kindly see the, my lord, order number 5.
Order number?
5. How someone has been accepted. How service of someone has been. Order number 5, page, my lord.
Yes, order number 5.
Order number 5. Yes. Page 39. 24/2/2026. Today is fixed for awaiting postal report. Believed report shall be considered together with postal report. On call, learned advocate for the plaintiff is found present by filing Hajira along with postal rack report and postal registration receipt. On perusal of the record, it appears that both the summons sent through register post and court could not be handed over to the defendant, as the door of the suit room was found under lock and key. Learned advocate for the plaintiff has prayed for accepting the service and fixed the matter for ex parte hearing. In support of such contention, plaintiff has relied upon decision of the Honorable Apex Court reported in heard the learned advocate for the plaintiff peruse the report, service report, materials on record, also peruse the citations relied by the plaintiff. Considered record reveals that after filing of the suit, summons have been sent to the defendant both through court as well as through postal mode. Record further goes to show that as per bailiff report dated 15 January 2026, the bailiff found room of the defendant was closed under lock and key. Well, this is a go down and lock and key. So far as the postal service is concerned, one envelope returned with the postal endorsement, intimation delivered, door closed. Section 27 General Causes Act, my lord. Thereafter, my lord, the next page, I am the Honorable Apex Court, my lord, this has been decision. Here in the present case, the envelope sent to the defendant through the post containing summons came back with the postal endorsement left. The postal article are proper.
Yes, what do you say?
There are 2 points, my lord. Firstly, my lord, we don't have an address of the defendant. Whatever the address we have sent to the summon on the appropriate
Service is not complete. How the point of limitation starts?
Yes. My lord, the second point, my lord, the service. The order of service has not been challenged. My lord, the third point.
The order of service?
Sir, now kindly see the order. My lord, the order was challenged only when the 7.1 application was rejected.
Yes.
Lord, the law is well settled. If the summon was not served properly, the limitation will count from the date of appearance. from the date of appearance if the summons was not properly served. From the appearance, the 1 month will be calculated. But from the appearance of 1 month, the deposit has also not been made.
No.
There is a settled law. They have
1
to make a
month,
deposit.
Mr. Chakraborty, have
My
been
lord, kindly
deposited.
see, my lord, I have
When you
appeared.
appeared?
My lord, I have appeared on, my lord, 25th of March.
And no deposit. The
Yes, yes,
application has been.
kindly,
Yes.
on 25th
No,
of
on the
March.
date of appearance, then
Yes.
within 1 month from the date of
No,
appearance.
my lord,
25th of March
26 I appeared, and my lord, my lord, my 7-1 has been rejected on 27.
When it was filed, 7-1 was filed
Yes,
when?
well, I'm telling
My lord,
you.
on
25 March.
25th.
It's admitted. 25 March.
Within 2 days.
Because it's admit.
Within 2 days, I have
With regard,
I have 28
they have to
days
make a
left.
deposit. The application has been preferred. No deposit.
I had
They could have
28
deposited before
days
the
in my
department.
hand.
Yes.
Because I appeared
But
on.
when it was rejected,
It was rejected on 27 March.
could not have been.
Within 2
Because he
days.
has 30 days. This application under Article 227 of the Constitution of India Yes.
We answer caveat. But the plaintiff is the petitioner.
I will not allow you to move. I've granted an accommodation to your junior on the ground that he will be moving. I will not allow you to move. He has not told that. I told him to take my brief. He said, oh, now I have the brief.
No, no, brief is with him.
He told he did not have the brief. So I gave him the brief. So if you are not ready, I will be taking up tomorrow. Please get ready. You are ready with this matter? Tomorrow. Yes. All the fixed matter. Yes, Mr. Mukherjee, which item? Flooded with Mr. Mukherjee is in court. Court is flooded with Mr. Mukherjee. Yes.
No, my lord. Yeah, Lord.
Who will argue? Mr. Bhattacharya has concluded.
Yes, Mr. Bhattacharya is not. My lord, just to refresh your lordship's memory, my lord. Lordship, here, my lord, initially, an eviction order was passed. Against the eviction order, an appeal was filed. Now, in the appeal initially, there was an order of stay. Now, my lord, the stay order.
That I do not know. That depends on him.
I will take up to
Mr. Mukherjee, post 29, if it is concluded, then I will take up.
He will continue.
Provided I do not stop him.
Normally, initially, an order of stay was granted. What an order of stay was continued for few months, and thereafter the same was vacated. After the same was vacated, well, they filed an application for extension. That extension was not granted. A civil.
Don't argue on facts. Give reply
No,
to
I
the law.
just to refresh your lordship's memory. And
you took possession on a date when the interim order was not there.
Yes.
1 day before.
Yes.
1 day before. So
Yes.
now argue on the law points. Don't argue.
Now,
on
Malad, in my argument, I have placed Malad, 3-4 points before you. First is, if order is not violated, status quo order cannot be granted. Then, Malad, if Malad situation has changed, interim order cannot be reimposed. Third, if the earlier order of status quo is not modified, so there was an status quo order, is not modified, impugned order cannot be passed. And then the conduct of the appellant in the trial court, that Malad, he allowed the interim order not to be in existence for more than 11 months. Now, Malad, I submitted on few judgments before your lordship. Malad, first was Malad 2008. Malad, on why Malad impugned or mandatory injunction can be passed. Then Malad, I passed an order that Malad, if the interim order is vacated, then Malad, interim order cannot be imposed. Malad, 1999 volume 2 SCC I have placed, where Malad is a very celebrated judgment. It Malad says Malad, status quo ante can be done on a compelling circumstances to undo some work which is illegal. So these were the argument I make. Now, Malad, in response, Malad, Mr. Bhattacharya, Malad continued and said, Malad, basically, the sum and substance of his argument is that Malad, and mandatory injunction order can be passed. I am also not joining issue. And he said, Malad, kindly recollect the impugned order says that, see, the conduct of me is not illegal, but is not reasonable. So on that proposition, he submitted few judgments. Now, before Malad, I distinguish Malad, the judgments which Mr. Bhattacharya has placed before your lordship.
My lord, I just want to make one submission before your lordship. My lord, the Code of Civil Procedure survived, my lord, for more than 100 years or so, more than 100 years. My lord, it survived, my lord, different challenge of virus challenge survived. My lord, the trial court cannot proceed on, my lord, perceived notion of morality. My lord, what the judge did is, my lord, perceived notion of morality. Whatever I done is unreasonable, illogical. My lord, in CPC, my lord, either I have done something rightly or I am done something not right. My lord, in CPC, there is no scope of perceived notion of morality. Number of the judgment placed by Mr. Bhattacharya is on read jurisprudence. Well, read jurisprudence, well, it starts, well, there is, well, we adopt CPC. But CPC is not included in the rate. And well, the read jurisprudence is always a fight between David and Goliath. So there is mighty state, and where, well, a citizen is coming before the court. So, well, the read jurisprudence develop on the basis of constitutional morality. And the constitutional morality part is, what is reasonable, what is unreasonable, what is arbitrary. These concepts are therefore is not, it cannot be imported in present facts and circumstances of this case, where a trial court came to a finding that no, there is no illegality in order. If that be so, that there is no question of perceived notion of morality. Now, let's kindly look at the judgment he placed. First judgment he submitted before the court is, AIR 1962 Supreme Court 1172.
Yes.
Now, if lordship takes, it is factually distinguishable. The judgment is the ratio was when contempt proceeding can be issued on initiated. Kindly two paragraphs. Your lordship kindly takes paragraph 2.3. Appeals from judgment and order of the High Court dated such and such. It found that two appellants of guilty of offence under contempt of court set and directed them punishment. The relevant facts are Gurbakh Singh responded in the two appeals was a
this was from a disciplinary proceeding.
Disciplinary proceeding, and the paragraph he relied on the basis of necessity. Paragraph 10 he relied on.
Yes.
And it is on the disciplinary proceeding and how that discipline proceeding is tried to be vitiated. And then this order was passed. So factually this judgment is completely distinguishable.
Yes.
Now the next judgment is a celebrated judgment of the Express Newspaper Private Limited, reported in 1986, Volume 1, Supreme Court Cases 133.
Yes.
Here the issue was, kindly takes the first paragraph, second paragraph.
Yes.
The petitioner challenged the constitutional validity of a notice of re-entry upon forfeiture of a lease by engineering officer such and such. So there was a forfeiture of lease and re-entry. So the question is the legality of the action. Kindly see paragraph 3. The petitioner alleged that the impugned notice of re-entry upon the forfeiture of lease threatened demolition of Express building,
yes,
the largest combined building, and are violative of such and such constitution. Daily printer such and such, such and such. So this is again completely factually distinguishable, because here he relied on a passage from paragraph, kindly grant me a moment, but it is not, the judgment itself is not at all applicable in the instant case, inasmuch as this was in respect
relied
of
on paragraph 117.
117, it is not therefore.
Yes.
Next judgment I need to place, it is AIR 1985, Calcutta 248.
Yes.
This judgment is on a status quo. But the factual Well, kindly have a look at paragraph 3, end of it. Because here a status quo order was subsisting, and therefore this order, I am agreeable to the proposition of law dictated by the court. Well, kindly come to paragraph 2, last portion of the paragraph to protect.
Yes.
To protect the plaintiff's property, plaintiff company engaged such and such service to provide security guards and search guard provided on and from such. Defendant was quite aware of the fact the rent of the month was duly paid and received by the defendant. The defendant, however, out of duly receiving the rent, in advance stated abusing security guards, preventing from interest and interest to security guard. And a complaint to the effect made was police. The plaintiff filed a suit such and such in the municip praying for an injunction restraining the defendant from interfering the plaintiff for right to ingress and egress of the suit property and for mandatory for all obstruction. On such and such, on an application for interim injunction, the learned municip and ad interim order directing maintenance of status quo and the plaintiff preferred an appeal. In appeal, plaintiff such and such, the plaintiff was not aware of the fact that the defendant surreptitiously taken possession. So, the fact is, hence filed the present suit for recovery of. So, the fact is there was a status quo order that was subsisting. Now, on the basis of that, he placed paragraph 8 of this judgment. Paragraph 8. I am completely agreeable to this judgment. But the fact remains, in our case, there was no status quo order. Paragraph 8 he placed. Perfectly correct judgment. I bow down to this judgment, but this judgment is factually distinguishable. Yet similar mandatory injunction order can be passed. Yes, can be passed. Now, paragraph 8, he placed paragraph 8 onwards. If I am correct. On careful rival contention before I proceed to consider by way of restoration on merits. Then, here putting padlock, lordship in mid of the that. In the point of suit, there was no allegation of dispossession of the first floor. What was being alleged was that defendant was wrongfully putting padlock on the outer those doors, making it such and such to access. So, in these circumstances, this order was placed. Now, the last judgment he placed, in 2004.
এটা খুবই আরেকটা কমপ্লেক্স ম্যাটার আছে ইনফ্যাক্ট দাদাই
Paragraph 8 and 9 he was relying at the time.
Of which judgment?
Of AIR 1985. So factually, ultimately the judgment in paragraph 8 and 9 says, in a situation mandatory injunction can be granted. I agree to this proposition. 1985 Calcutta. Paragraph 9, so far as the reason.
So according to you, this is a judgment where in violation of an order of injunction, the possession is taken, yes. Mandatory injunction can be passed.
Yes, in paragraph, I just placed paragraph 3, here was an paragraph 3, paragraph 3, paragraph 2, paragraph 2. The paragraph 2 and from the first page of just above paragraph 3, that paragraph. On March 29, 1982, the plaintiff filed a suit being titled suit number such and such in third court of the learned municip of Alipur, praying for an injunction restraining the defendant from interfering with plaintiff's right to ingress and egress to the suit property and for mandatory injunction for removal of all of obstruction. On March 30, on an application for interim injunction, the learned municip passed an ad interim order directing maintenance of status quo. And the plaintiff preferred an appeal on such and such. The appeal.
When the order of injunction was passed? When the order of injunction was passed?
On April 1, 1980.
When the disposition took place?
the disposition took place, kindly. The Appeal 2050 on the file and Sajansa 82. First time she had taken position on the said file, the plaintiff was not aware. 1982.
When date?
Next part, next line.
Yes.
In Appeal, the plaintiff company filed an application for temporary detention to which affidavit on affidavit was filed by defendant number 2. April 19, alleging that hearing for the first time she had taken possession of the flat on March 24, 19.
Yes. So it's a prior date to the filing of the order of injunction.
The plaintiff was not aware of the fact that defendant was surreptitiously taken possession of the property.
So this was a case, Mr. Nag. Yes. So injunction, prior to the injunction, possession take.
But that was not made to the person. Not known.
So in that case also, even without the injunction, restoration.
Without the injunction, restoration. But where, my lord?
You are saying that you are not disputing, not questioning this proposition. This is an authority which is not in violation of an order of injunction, possession taken. That is also one of the judgment. It's a year after that, year 1986, Calcutta.
Yes.
On that, yes, in violation of that. But here is a judgment which is prior to that.
But when the fact remains, the interim order was passed was on the understanding that they are in position. They are in position when the application for injunction was sought for. The plaintiff was on belief that he is in possession of the property, and then status quo order was passed. Thereafter, surreptitiously it was found that he has taken possession.
Status quo ante.
It was alleged.
Status quo ante.
But one thing I can say, it is the defendant who has said before the court that I have taken possession prior to. But there is no definite finding in the court. Kindly.
Yes, there is a finding, Mr. Nag. This judgment. There's an entire discussion in this judgment. This judgment is an authority on that.
Kindly come to paragraph 8 middle. Those paragraphs of the plain, those paragraphs of the plain was clearly pleaded that the plaintiff has been in quiet and peaceful possession of the suit property until March 1982, when the defendant started abusing and harassing the plaintiff's main agents in the matters of getting access to the suit property. In the plaint of the suit, there was no allegation of the disposition from the first court. What was being alleged was that defendant was wrongfully putting padlock on the outer door, thus making it difficult for the plaintiff to getting access to the first floor. As a matter of factum of disposition was not known to the plaintiff under April 2, 1982, when for the first time defendant disclosed the fact such and such. That was a simple suit for injunction, while the present suit based on different cause of action, namely disposition itself which arose on such and such. These being a suit for recovery of possession. So, the suit for recovery of possession on declaration tenancy right along with damages more than such and such. So this was a separate suit that has been filed. Under 6 of the specific relief act. Thus, the cause of action of two suits are totally different. In my opinion, the learned subordinate word error in thinking that the present suit prima facie barred under provision of Order 2, Rule 2 of the Code. So far as the second reason assigned by the learned senior judge, I feel that it is necessary to clarify the position with regard to prayer for injunction amendment in the present case. After hearing that they filed a separate suit, and when this order was passed. So again, therefore, it is factually different. Saying that if I filed a suit previous, I was not known. Second, when I known, I get to know, my lord, I file a separate suit under 6 maybe under specific relief like to get back the position. My lord, in that case, this order can be passed. This is not on, my lord, the status quo and violation and all. My lord, the proposition which I argue. Now, my lord, the last judgment he referred to is, my lord, Lordship 2004, Volume 4, Supreme Court cases 697. Now, my lord, again, this is, my lord, basically an election petition. Lordship will find, my lord, the paragraph 2, such and such is a cooperative society falling with one of the categories, such and such, that makes special provision for election. Then, my lord, here an interim order was passed. Paragraph 11 he placed. Lordship will find the courts and tribunals cease with the proceeding with their jurisdiction to take reasonable time. This is fair procedure. Now, my lord, here what happened, my lord, in spite of that, my lord, kindly look at the fact once. My lord, paragraph 6, if Lordship takes. Paragraph 6. On such and such, the appellant filed his nomination paper. Receipt whereof was issued by the returning officer. There was no on security. Nomination filed by the appellant was found to be in order. There was no withdrawal. At 2 p.m., only 4 directors, including appellant, of total of 8 directors of the Sangh was present. The returning officer awaited Tahsildar to draw up the proceeding special meeting recording fact relating to notification of elections.
So according to you, this was an election matter.
Election matter, my lord. And election matter, my lord, the this interpretation of status quo and strong prima facie case of record is completely different. That is to survive that proceeding of the election proceeding is not nothing to do with my case. Now, my lord, here and my lord, to sum up, my lord, the points I urged, my lord, in respect of 2-3 points, there was no reply basically. My lord, in respect of basically the point of, my lord, if the interim order, if, my lord, situation has changed, whether the interim order can be, and there is also another portion. My lord, there in the last order, there was indeed a status quo order passed. The earlier order, there was a status quo order. After I took possession, the status quo order needed to be valid. Well, in their application, if the prayer Lordship kindly takes, well, it is very important. Page 128. Well, they
128.
128. They indeed made a prayer because they knew without modifying the earlier order, this order could not have been passed. And well, holding that I am unreasonable,
128.
120. This is his petition.
Yes.
In the premises, the appellant petitioner humbly prays that your honor be graciously pleased to, first, to modify and vary the order dated June 17. This is the order of status quo, which is still continuing, and direct removal of padlock from the main gate and direct status quo entry. So the first portion was not granted. If the status quo order, which has been passed by the same court, has not been valid, well, how can a status quo ante is passed by the same court? Now, this is my submission.
Nothing in reply, only one sentence. One sentence I'll stop. They had made a submission that we are not avoiding the court or our conduct is not proper. I informed your lordship that the proceeding is on the verge of culmination because the matter was fixed before the learned court below the main appeal. Now, dates were fixed on the 29th of July and for them, and 1st of August also for submissions of the learned advocate. I am told that
29 George Bosini.
29, the court was not available, and 1st August, my learned friend or his counterpart there had a problem, and therefore owing to their problem, the matter has now been posted to
September.
2nd September.
It's neither here nor here. That is not the part of
the conduct. He said conduct of my lawyers was improper.
Conduct of 1 day versus conduct of 11 months. Well, I don't want to go into this. I urge 3-4 point of law on the basis of that. My senior taught me if you have a case which is bad in fact. Argue the point of law. I have argued, whatever in my little capacity, the points of law, I tried to impress upon your lordship. I am leaving it to your lordship. I have
Heard Mr. Nag, learned advocate.
No.
দিয়ে দেবে তিনি
List of citations. List of the only citations. Because I've noted, but if I've missed something, because there's a long gap, that is why otherwise only the citations, you need not give copies because copies are here. So only
you relied on 4, he relied on 3. 4 plus 3, 7. 4 plus 3, 7.
তাই তো আমরা বেশি